information. Mr. Braswell and Mr. Anderson are also absent today. So Mr. Thorwald.
Here, no conflict.
Ms. Nair.
I'm here and I have a recusal on 8A and 15E.
Ms. Davis.
Present, no conflicts.
Ms. Walmsley will be late. Ms. Spark.
Present, and conflicts have been submitted in writing.
Mr. Hogan.
Present, no conflicts.
And Mr. Al-Nassif.
Here, my company is 22J.
We're all set to go, Madam Chair.
Perfect. We're going to start with the tab 4 consent agendas. We're going to pull out 4D as it's been set aside for full board review. There wasn't a quorum in the complaint committee. And then we'll take the rest of them in as one. So
I'm recused from this one.
oh, thanks. Do we have enough?
Second.
We have to have 5 for a quorum, Madam Chair, so it should be all right.
Okay, perfect. All right. Any discussion on 4D? This is a case where it looks like there was maybe some miscommunication between a delivery request and a pickup request, and then a human error where a pharmacist sold a patient's family member the wrong bag of medications.
From my perspective, the miscommunication is just customer service issue. I don't think that's violate any rules from our perspective, from my perspective at least. Regarding the human error, we have our standard of 3 hours non-disciplinary CE for the pharmacist, and usually we dismiss the permit order.
Would you like to make that your motion?
This is my motion.
Before we proceed, it doesn't look like they checked it out through the system. Did they not pay for it? I was a little confused on what happened, or it had been prepaid and they didn't ask the date of birth and just handed them the medication.
Yeah, that's exactly. I mean, my understanding from reading the complaint here, that they got this medication ready to the side. Patients came to the drive-through window, asked for it. I believe they asked for date of birth for sure and name, but they grabbed their own bag and give it to the patient, unless our compliance officer has
I was just going to ask Mr.
more details.
It looked to me like it was set for delivery, so it had already been paid and checked out through the
Yeah.
process. And then the patient called and said that she changed her mind and was going to pick it up, so they pulled it out of the delivery bin and put it on the counter.
Yeah.
And I saw it this way. They didn't do the process they were supposed to do. So bypassing the process, we've considered discipline when we knowingly bypass the process.
So do you have any details? I'm sorry for that.
So Dennis Wagner, compliance officer. I think what happened was in the heat of the moment, let's say, when the patient came through the drive-through window, the pharmacist just reached into that area and grabbed the wrong bag, and that's what went out the door. When the patient realized that they had someone else's bag, they brought the bag back unopened.
So, but the process I would suspect would be to check them out through the computer, ask their date of birth, at least get their health information, private health information, and verify that. So that was not done, correct?
It does not appear that that occurred, correct?
So I saw it a little differently than I guess what you're saying, because when someone bypasses the system that's put in place for safety, we've given discipline. I think that would be consistent here.
I think it's, it's obviously a human error, and the contributing factor of the patient asking for delivery and then changing their mind and asking for it to not be delivered, I'm sure caused a little bit of hiccup in the normal process.
And like most of the error happens because people not following policies. If you're gonna go through this, right? Like if everyone follow the policy and go by book, I believe the error would be very, very minimized with less cases here. So from my perspective, it is a lot back and forth before the pickup, right? Patients rep decided to come to pharmacy to pick these medications. We don't know what's happened before. And to me, it's just error happened, human error. I don't know if they have any policy for like something set up for delivery and then the patient decide to pick it up because pick medication instead of like wait. But to me, error is error. It is a human error for sure. It's just like intentionally happened or like maliciously happened. I don't see it that happened this way, or neglect or ignorance. I don't know what was the situation at that moment.
If I
Yeah.
could add, I don't think
Yeah.
this was a deliberate act of not following policy.
All right, well, I have a motion. Would anyone like to make a second?
Could you repeat the motion?
It is like our standard. Dismiss the permit holder and 3 CE education, continuous education, non-disciplinary, 3 hours for error prevention for
I'll second that.
pharmacist.
Okay, I have a motion and a second. Any other discussion?
Sorry, Mr. Nassif, did you say just the pharmacist or pharmacist?
I believe only pharmacist is listed. So yeah, and dismiss the permit holder.
All right, all those in favor? Aye. Any opposed?
Nay.
All right, motion passes. 4Q has been tabled, so I would entertain a motion to accept the complaint committee's recommendations on tab 4.
I'll make a motion to approve the recommendations on tab 4.
I second.
All right, I have a motion and a second. Any other discussion? All those in favor? Aye.
Madam Chair, I'll take roll call on that. There may be discipline
Oh,
involved.
sure thing. Go for it, Dr.
Mr.
Carney.
Braswell is absent. Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley's gonna be late, Ms. Spark,
Aye.
Mr. Hogan,
Aye.
Mr. Al-Nassif.
Aye.
And Mr. Anderson's absent. Ayes have it, 6 ayes, 3 absent, Madam Chair.
Great. I promised Mr. Hogan that we would take these tabs one at a time in case he has a comment. So I will also next accept a motion to approve tab 5 consent agenda, refer to administrative hearings for 5A, 5B, and 5C.
I second.
Okay, I have a motion and a second. We need roll call on this one, Dr. Gandhi. All right.
I do have one quick question. On 5A, did we send it to the address that the Arizona Department of Safety has? Because it looks like we only sent it to one address. There are 3 addresses listed in this full, all the documents that we have. But the one the Arizona Department of Safety has could be a potential way to contact the person.
We only sent the complaint notice to the address of record that we have on file. The address that the Department of Public Safety has might not be any more accurate than ours, given that they applied for that fingerprint clearance card before they applied for licensure with us.
Okay, I do have a motion and a second. Is there any other discussion? All right, all those in favor of approving tab 5? Any opposed? All right, we're gonna move to tab 6, consent agreements. On this one, I'll entertain a motion to accept tab 6 unless anyone has any that they'd like to pull out for discussion.
I'll make a motion to approve tab 6.
I
Second that motion.
Okay, I have a motion and a second. All those in favor?
Madam Chair, we would
Oh,
need a roll call.
We'll need a roll call on
Yep.
that one.
Thank you. Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley is absent, Ms. Spark,
Aye.
Mr. Hogan,
Aye.
Mr. Al-Nassif.
Aye.
Mr. Braswell and Mr. Anderson. Ayes have it, 6 ayes, 3 absent, Madam Chair.
Thank you. Tab 7 is vacant. I'll entertain a motion to approve tab 8, which is license and permit ratifications.
I'm recused from 8A.
I move to accept tab 8.
I have a motion. Do I have a second?
Second.
Okay, I've got a motion and a second. Any other discussion? Maybe Ms. Nair, you could just vote I accept 8A. All right, all those in favor?
Aye.
Okay,
Aye.
Any,
Except 8A.
any opposed? All right, perfect. Let's go to tab 9 and agenda item 9A, complaint 25-0169. Great, thanks for being here. Let's introduce ourselves, starting with Ms. Brown.
Jenica Brown, Executive Assistant to the Deputy Director.
Alex Snyder, pharmacist attorney with Corals.
Thomas Velasquez, pharmacist.
Thanks for being here. Can we get a summary, Ms. Brown?
Certainly. Thomas Velasquez was issued an Arizona pharmacist license by Reciprocity on January 29th, 1986. His license expires on October 31st, 2025. It is currently open and on probation. On or about December 2nd, 2022, board staff was informed that an internal investigation was being performed at Bash's number 109 concerning improper record keeping and to determine whether any controlled substances were missing. On December 21st, 2022, Bash's number 109 submitted a DEA 106 indicating controlled substance losses, which involved 54 different drugs totaling 6,814 dosage units. Bash's provided an amended DEA 106 on June 20th, 2023, reporting losses on 51 different drugs involving 5,167 dosage units. According to Bash's, the losses were initially discovered when a floater pharmacist raised concerns about the accuracy of the C2 perpetual log. In response to the complaint in this matter, Mr. Velasquez acknowledged poor record-keeping practices. The board considered this matter during the October 2023 board meeting and voted to offer Mr. Velasquez a consent agreement for probation, civil penalty, and continuing education in board case number 22-0735. Mr. Velasquez signed the agreement and it was executed on April 11th, 2024, which placed his license on probation for a minimum period of 12 months. On February 27th, 2025, Mr. Velasquez contacted board staff and requested an appearance before the board to request termination of his probation. Staff confirmed that Mr. Velasquez paid the civil penalty and completed the continuing education requirements outlined in the consent agreement. Upon preparing his file for the board's consideration, it came to staff's attention that Mr. Velasquez may have changed employment in June 2024. Staff did not have any record that Mr. Velasquez notified the board of the change of employment in writing, nor did staff receive written confirmation from his employer and pharmacist in charge that they receive a copy of the consent agreement as required by the agreement. Board case number 25-0169 was then opened to investigate the possible violation of his consent agreement in board case number 22-0735. Staff requested employment history from Mr. Velasquez from April 2024 through current date. He indicated that he worked at a pharmacy through a staffing agency on 4 separate dates between June and July 2024, in addition to 4 separate dates in August 2024. Staff requested confirmation of whether or not he supplied a copy of the consent agreement to the pharmacy and whether he notified the board in writing once he obtained employment as required by his consent agreement. Mr. Velasquez indicated that he did provide the pharmacy a copy of the agreement, but he missed the written part to the board. He also verified that he is not currently working. Staff sent Mr. Velasquez a notice of complaint and requested a response as to why he did not ensure that the PIC submitted a written acknowledgement to the board, and a response as to why he did not notify the board in writing within 5 days of obtaining employment as required by his consent agreement. The PIC of the pharmacy Mr. Velasquez worked at subsequently emailed staff on March 27th, 2025, indicating that she received a copy of Mr. Velasquez's consent agreement, but she was not made aware that she needed to submit written acknowledgement to the board. Her email is included in the board's files for consideration. On April 4th, 2025, board staff received communication indicating that Mr. Velasquez retained counsel for board case number 25-0169. His attorney submitted a response to the complaint on April 10th, 2025, which is included in the board's files for review and consideration. This matter is before the board for discussion, consideration, and possible action regarding board case number 25-0169, which was open for possible violation of a board order, as well as Mr. Velasquez's request to terminate the probation of his license in board case number 22-0735.
Thank you, Ms. Brown. Mr. Snyder or Mr. Velasquez, would you like to make a statement?
Absolutely. Thank you for taking the time to allow us to appear before you today. So my name is Alex Snyder. I am serving as legal counsel for Mr. Velasquez here with respect to complaint 220169 and its request to end the probation. So in a moment, I'll turn it over to Mr. Velasquez, but I just wanted to kind of provide some perspective and shed additional light on the matter so I could set up a baseline for the board today. So as Ms. Brown indicated during the October 2023 meeting, the board decided in a 5-4 decision to issue discipline against Mr. Velasquez to address the alleged allegations included within case number 220735. And then that consent agreement as a part of that discipline was finalized on April 11th, 2024. The consent agreement included a probation, civil penalty, and continuing education requirements. In accordance with this consent agreement, Mr. Velasquez completed the required CE credits and paid the civil penalty fairly promptly. And then under this probation, as Ms. Brown alluded to, he was responsible to adhering to certain notification and acknowledgement requirements should he enter into employment, having lost his previous pharmacist position as a result of this original complaint. So unfortunately, as a result of the discipline and the probation on his license, Mr. Velasquez experienced some level of difficulty finding employment as a pharmacist, permanent, temporary, or otherwise. Finally, through a contracting agency, Mr. Velasquez was able to pick up temporary shifts at Capsule Pharmacy while a full-time pharmacist was on leave. And as Ms. Brown indicated, those were a total of 8 shifts total over a 2-week period spanning between the end of June, early July, and in August of 2024. Mr. Velasquez notified the PICA capsule and that he was on probation, provided a copy of his consent agreement for review. Unfortunately, the PIC never sent a written acknowledgement that she received a copy of the consent agreement, as evidenced by the communications within your board file. And while he did update his online profile, he had every intention of alerting the board that he had changed employment. He unfortunately did not submit a written notification, nor did he ensure that the PIC submitted a written acknowledgement that she had reviewed the consent agreement as well. So right now I would like to hand this off to Mr. Velasquez, but before I do, we would just like to respectfully ask that the board decide to dismiss this complaint and end his order of probation. Thank you for your time, and I'll turn it over to Mr. Velasquez.
Okay. Thank you for allowing me the opportunity to speak with you today. To begin, I wish to convey my serious apologies for appearing before the board regarding this matter. As my attorney had just explained, I accepted the order of probation placed upon my Arizona license and had every intention of complying fully with the terms of the consent agreement for the year it was in effect. As required by the consent agreement, I paid the civil penalty and completed the continuing education relevant to the complaint. I at no time wished to circumvent or violate any order of probation, and I am as upset and frustrated with this mistake as anybody. I was unemployed when the order of probation went into effect last April, having lost my pharmacist position as a result of the facts that led to the original complaint. From a practical perspective, I quickly found that the probation upon my license made finding future employment difficult, even though the terms of the consent agreement allowed me to practice generally. Nevertheless, I was able to find temporary employment on an as-needed basis for Capsule Pharmacy, working a total of 8 shifts over a period of 3 months. Last summer, I updated the Arizona Board of Pharmacy portal with this temporary employment and presented the consent agreement with the order of probation to the pharmacist in charge of Capsule Pharmacy. That was Elaine. Even though I always knew that the job was temporary, I had every intention of complying with the terms of consent agreement and order of probation. However, unfortunately, I did not submit a written notification to the board, nor did I follow up with the pharmacist in charge of Capsule to ensure that she submitted a written acknowledgement that she was aware of my order of probation. For this oversight, I'm very sorry, truly sorry. As I am sure the board can understand, this entire matter has been extremely taxing on both myself and my family. Prior to this event, I had never had any action taken against my Arizona license. Any non-compliance can be accompanied to my unfamiliarity with the process and not a willful deviation. However, I understand that the board expects me to understand the exact requirements of the consent agreement and order of probation, including the written notification and acknowledgement requirements. In that, I take full responsibility. Again, I wish to convey my serious apologies to the board and their staff. My intent has been and has always been to comply with the Arizona Pharmacy Practice Board regulations and any stipulations placed upon my license so that I may best serve patients in the state of Arizona in a safe and effective manner. And at this time, I'm happy to take any questions you may have.
Thank you both. Any board members have any questions for Mr. Velasquez or Mr. Snyder or Ms. Brown? Or any discussion?
So, so normally if pharmacists change employment, they just go to the portal, right, and submit change. But since he was on probation, so we required him to send a written like email or letter to the board, right, to
The
change his.
the pick at where he was working was supposed to send acknowledgement there where that he was on probation.
Okay, so
If
now
I may,
to
there is a requirement for the pharmacist, the respondent, to submit written notification of change of employment to staff as well. So it's not only the pick of the place that he's obtained employment, but it's also he notifies us himself that he has changed employment, and neither of those things happened. It's a provision of his probation.
But not work.
Tariq, do you want to continue? It looks like we're back.
okay. So like regarding Pick did not acknowledge, I don't see he did any wrong on this thing. He should have like follow up with the Pick to make sure that send a board of pharmacy. So I still have a concern about not following the consent like agreement to send us a letter message, and this is obviously to me is like violating the probation term. The fact that he was planning to come before us to remove the probation, now we are facing a violation of the probation. That's make it difficult for me to accept left his probation because of this. I don't know if we just, so my opinion, just like to, do we have it before us, like to lift his probation? So at this time, I will deny his request.
So right now we're dealing with a complaint. In just a moment, we'll deal with 22A, which is the probation removal request. But right now we have to decide what to do with this initial complaint that he didn't notify the board of the change in employment in writing, and the PIC of that location didn't submit acknowledgement that she'd received a copy of the consent agreement.
And that's why I believe if we can do the same role on both of them, you know what I mean?
Calvin,
Because
I think
yeah.
it makes sense to put both of them together if they're going to consider the probation along with the violation of the term of the consent agreement. Would you agree, or?
If they are considering anything but extending the probation, then they could consolidate them and deal with both of them at the same time. Or they could adjudicate the complaint, as Ms. Davis was saying, determine what you think may be appropriate for that. But if you feel that the complaint alleged violations would justify the extension of probation, then you could handle it together. Are you wanting to receive legal advice?
Yeah, I move for legal advice.
A second.
Okay, I have a motion and a second for legal advice. All those in favor?
Aye.
Any opposed? Okay, we'll be right back. Welcome back, everybody. Do we need to do roll call or anything? Okay, get right into it. All right. Mr. Al-Nassif, did you want to kind of continue your thought from before?
Yeah, I believe just we discuss those two items separately. I don't know if anyone has any.
I'll make a motion.
Yeah.
Overall, you were pretty compliant with what was expected in the board order, but your partial compliance is why we're here today. So I'll make a motion for a $250 non-disciplinary fine for not completing the board order as directed.
Second.
Okay, I have a motion and a second. Any other discussion? Do we have to do roll call? Okay, all those in favor?
Aye.
All right, any opposed? All right, that passes. Let's go to item 22A, which is Mr. Velasquez's request to terminate his probation.
I'll make a motion to terminate the probation.
Second.
All right, I have a motion and a second. Any other discussion? All those in favor?
Aye.
Any opposed? Congratulations, Mr. Velasquez. Your probation is terminated. Board staff will be in touch about that $250 fine. Thanks much. Okay, next we're going to go to 9B, board case 23-0656. Oh, great. All right, can you guys introduce yourselves, please, to start?
Jenica Brown, Executive Assistant to the Deputy Director.
Good morning, Chair, members of the board. Flynn Carey, counsel for the licensee. I believe he's available on Zoom.
Mr. Q, are you there?
Yes, ma'am. Good morning. I'm here.
Hi, welcome. Thanks so much for being here. Ms.
Sure.
Brown, give us a summary of the case, please.
Certainly. Anthony Q was issued an Arizona pharmacist license by Reciprocity on April 5th, 2022. His license expires on October 31st, 2025. It is currently open. On November 28th, 2023, Walmart Pharmacy notified the board that Mr. Q was terminated on November 27th, 2023 for violating the pharmacy's arrested associate policy. Board staff sent Walmart a subpoena for records to obtain further information regarding the termination. Walmart responded to the subpoena and provided documentation indicating that Mr. Q did not report an arrest for a DUI within Walmart's required 3-day time period. The documentation further disclosed that in January of 2023, Mr. Q reported to work in a condition that may have made him unsafe to practice pharmacy. The details of this event are contained in the board's files for review and consideration. On December 20th, 2023, board staff sent Mr. Q a notice of complaint and subpoena for records related to his arrest on or about November 16th, 2023. On December 28th, 2023, staff received a notice of representation. Mr. Q's counsel submitted a response to the complaint on January 12th, 2024, indicating that Mr. Q had not been charged with any offense and that the situation involved medical events. The complete response is included in the board's files for review and consideration. With respect to the subpoena for court records, Mr. Q's counsel indicated that Mr. Q has no documents in his possession or control responsive to the request, and an explanation that many jurisdictions wait until blood results are available from the crime lab before filing charges through the prosecutor's long-form process. Board staff regularly followed up with Mr. Q's counsel between January 2024 and July 2024 regarding the police report and toxicology results from Mr. Q's arrest in November 2023. During this time, no charges were filed and no toxicology results were available. On July 29th, 2024, staff received a copy of the police report from his arrest. The report is contained in the board's files for review and consideration. On October 30th, 2024, board staff contacted Mr. Q's attorney for an update on the toxicology report and any further information related to the status of the matter with the courts and law enforcement. Mr. Q's counsel confirmed that there were no charges to the status of the matter. No charges had been filed, and toxicology results had not been made available. On November 7th, 2024, staff contacted Mr. Q's counsel and requested medical records related to Mr. Q's event in January 2023. Mr. Q's records were received and they are contained in the board's files for review and consideration. On March 4th, 2025, staff contacted Mr. Q's counsel and requested documentation supporting the lack of toxicology results in the matter. Mr. Q's counsel responded and indicated that the statute of limitations for a charge had passed and no criminal complaint was filed. On March 13th, 2025, an interim order for an evaluation was issued to Mr. Q. Mr. Q's counsel notified staff that Mr. Q is not presently practicing and is physically residing in Georgia. Mr. Q complied with the order. The results from his evaluation are included in the board's files for review and consideration. Staff supplied a copy of the evaluation to Mr. Q's counsel on May 27th, 2025. Staff offered Mr. Q the option to enter into an interim consent agreement for voluntary suspension of license in order to undergo the additional evaluation recommended by the evaluator, as well as the option to voluntarily surrender his Arizona license. Staff indicated that if he did not wish to enter into either agreement, the matter would need to be considered by the board. Mr. Q's counsel responded on May 29th, 2025 with an alternative proposal, which is included in the board's files for review and consideration. This matter is before the board for discussion and consideration of the facts of the complaint, the results of the evaluation, the proposal from Mr. Q's counsel, and to determine next steps in this matter.
Thank you, Ms. Brown. Mr. Flynn, would you like to make a statement?
Yes, thank you, Chair, members of the board. I'm going to speak very briefly at this time, and I would ask the board to consider utilizing your power to do an executive session on health information. As you heard from Jenica, she was very careful around some of the health issues. This isn't a DUI case. That's just the bottom line. And I think it needs to be reviewed under a different lens of an organic issue that I think needs to be addressed potentially through another means. Ms. Galvin and I did have the opportunity to visit yesterday. I have some thoughts on how this could be resolved. He doesn't intend presently to go back to practice, but I think that a disciplinary outcome to facilitate that is probably the wrong answer, because this is very different than a case where someone, for instance, is diverting, has a drug or alcohol issue or anything along those lines. And so I think some deference to the health issue should be explored on this case. Other than that, I can make some other comments, but I think they're more appropriately heard in a confidential executive session for health.
I move for confidential.
I have a question, if you don't mind. What is your proposal?
I think we can resolve it with a letter agreement or an agreement that essentially he's going to allow his license to expire in, I believe, October of this year. He's not intending to go back into practice presently, and I can provide you some more information on that in an executive session. But the idea would be essentially that he would agree not to practice. It is a model that has been, we've done this before in front of some other boards. And so essentially there's a mechanism in place that there's an agreement between the board and the licensee.
He doesn't reside in Arizona either, right?
Presently, he's residing in Georgia with family. He moved out after this incident to be closer to family, so he has some supports out there.
What's the difference between your proposal and a voluntary surrender?
Voluntary surrender is a revocation. It is considered disciplinary in nature. And so the idea is it feels like the wrong fit when someone is essentially complying with everything the board's requesting. They haven't done anything that's a violation of the Practice Act, but there may be an issue that's causing them to be in a position where they're unable to practice. I think this gives someone, it honors their health situation. It doesn't put discipline on their record, which could obviously have implications for the future if his condition were to change in a way that would make him amenable to return to practice.
Ms. Galvin, do you have any risk concerns about that?
About their proposed, we can discuss that in executive session. I can offer that opinion in executive session if your motion includes legal advice as well.
Yeah, I modify my motion to include legal advice.
I'll second.
Okay, I have a motion and a second. All those in favor? Okay, any opposed? So we're going to do legal advice before executive.
To do it would make more sense to do the protected health information, get all of that. And then if you need legal advice, we can remain in legal advice. And then Mr. Q, he should receive an invite. Is that correct? Okay.
Okay, we'll be right back. Okay, welcome back, everyone. Thank you for your patience. I think after the discussion, I'd like to make a motion to accept Mr. Flynn's proposal of entering into a memorandum of understanding with Mr. Q, allowing his license to expire in October, based on recommendations from the evaluator. Anything else I need to add, Ms. Galvin? Staff will work out the specific details.
Second.
I believe that's sufficient.
Okay, I have a motion and a second. Any other discussion? All right, all those in favor?
Aye.
Aye. Any opposed? Thank you for being here today.
Thank you.
Mr. Q. We're gonna take a bio break. It's 9:50 right now. Let's come back at 10 o'clock. Welcome back, everybody. I'd like to kindly request that members of the audience, if you're going to have conversations, step out into the hall so it's not distracting to the other people in the audience or to members of the board. Appreciate it. Mr. Rain has some appointments to attend to, so we're going to move a little bit out of order and move you up. We're going to start with 13C, which is a non-resident wholesaler permit for Physio Control Inc. I believe that compliance officer on this one is Mr. Wagner. Oh, sorry, Mr. Patel. Mr. Jacobson. All right, thanks, everyone. Can you, compliance officers, please give us a summary of this non-resident wholesaler permit?
Hello, members of the board. Physio Control applied for non-resident manufacturer and wholesaler permits. During substantive review, it was discovered that this company disclosed discipline for shipping into Kansas without a permit. The discipline occurred recently on March 20th, 2025. Per legal counsel, there was over 5,000 items that have been shipped into Arizona prior to having a permit. Counsel stated that many of the items are prescription only, but it is unclear exactly how many are prescription only. This company is affiliated with Stryker Corporation, which signed a consent agreement in April of 2024. However, these two permit applications are not part of the Stryker consent agreement that is already in place.
I have a question about that, just real quick. Was this company purchased by Stryker since the consent agreement?
Yes.
All right, perfect. Anything else from you? All right, Michael Rain, would you like to make a statement?
Yes, just, I mean, perhaps briefly, before the meeting, we had communicated with board staff with a request to actually table this matter. And there's another matter on your agenda, 15B, for the same company. Perhaps because of the timing, we were told that we would present that request to this board. So the request is really to table this to your August meeting. Stryker does have a handful of additional licenses going through, or applications going through the processes. The hope was that we would come back in August and address those issues more globally like we had done in the past. At least for the record, I would say that Stryker would disagree that this or any other pending applications weren't part of the process that we had several months ago, or years ago, really. There were many non-resident manufacturer, wholesaler manufacturer applications that were addressed in that, but they weren't named on your agenda. They weren't identified in the consent agreement. Even in the meeting, some were identified for the first time to us as having been closed, and then they were resubmitted. So it's our position that what the board decided when we resolved this issue with Stryker was that the resident locations would receive a civil penalty, a very, very significant civil penalty, and that all non-resident applications would receive a non-disciplinary letter of concern or advisory letter, along with, of course, meeting all the standard conditions for licensure. So it would be our position that all further non-resident applications dealing with the same issue of potential pre-permit activity would also receive that advisory letter. But with that comment, I think the request is just to table these matter for today and bring it back in August.
Do we need a motion to table? So the request is to table 13C and 15B?
Correct, thank you.
Would any board member like to make a motion to table those until the August meeting?
Yeah, this is my motion to table those two items for August meeting.
Second.
Okay, all those in favor? Aye. Any opposed? Okay, all right, thank you. You're gonna stay up here, I think, and we're gonna do 13C. Oh, sorry, no,
D.
13D.
Okay. 13D is a non-resident wholesale permit application for K2M. K2M applied for a non-resident wholesaler permit and has disclosed discipline for this location. This company is affiliated with Stryker Corporation at the time of writing. It is no longer affiliated with Stryker Corporation since it is currently under change of ownership. And this was previously signed and included in the consent agreement with the Arizona State Board of Pharmacy in April of 2024, whereby this location was part of the consent agreement. There was also a change of ownership, there was a change of ownership which occurred on October 31st, 2024, but the application for change of ownership was not filed until December 19th, 2024, a couple of months later. R4-23-601 requires that a permit holder apply for a new permit within 14 days before there is a change of ownership. This application is in front of the board for consideration due to the untimely notification for the change of ownership.
Mr. Rain, would you like to make a statement?
Yeah, briefly, again, this was one of the items that we had requested that the board table to its August meeting. This one, however, is a little different because it was a change of ownership application, but subsequent to that application that's in front of you, there was a full divestment. Stryker no longer owns this. There's been a subsequent change of ownership application by a new owner that is now pending. It would seem to be, moot. The change of ownership application part is moot, we would say, because there's now been a new change of ownership that's going to come before you. But whether you make any decision about it today, we can also table this. We would request to table it to August if necessary, but we're not sure that it needs to be dealt with any longer since there's a new change of ownership with a new
So
owner.
the purpose of tabling would just be, there would be another change of ownership?
No, I mean, our hope was to table all of these matters just for efficiency. Now that we're sitting here in front of you, if there was a way to conclude it, we'd be happy to explore that with you or staff. But there was Stryker's internal, they had a restructuring. It wasn't like 100% change of ownership environment. Subsequently, there was 100% change of ownership that another company has filed that change of ownership that's currently pending.
So this failure to disclose, is there any reason we couldn't just adjudicate it with a $250 civil penalty for failure to disclose a change of ownership in the 14-day period? And then you guys could be done with the K2M business, and then the new company would be free to pursue its new permit,
And
right?
the new company would timely notify the board, so then you can move on.
I'll make a motion to for a $250 civil penalty for failure to disclose a change of ownership within 14 days.
Second.
Right. All those in favor? Aye.
Aye.
Any opposed? Right, thank you. Okay. I think we're gonna go to 15D. B.
B as in boy. That was tabled, I'm sorry. And then
21A.
21A. Yep.
Okay, we're gonna go to 21A. This one is Mr. Wagner. This is conference for complaint 24-0485. Respondent Evelyn Magoka, Stephanie Cowdrick, and Costanoa Health Systems, DBA Phil RX. Hi, Mr. Wagner. When you get prepared, can you give us a summary, please?
I will do my best. So a complainant alleged that a pharmacy had no security or measures to ensure someone's safety, as well as allowing unlicensed technicians to perform data entry of prescriptions. Specifically, she mentioned that there was no locking mechanism or identification required to enter the pharmacy, as well as identifying 2 technicians who were entering prescriptions without a license. A response from counsel indicated that the pharmacy had an electronic badge reader that was temporarily disabled at the time of my visit, which was approximately 2 weeks after receipt of the complaint. The badge reader has been activated and additional badge readers have been installed on other entrance doors. Counsel acknowledged that technician EM license had lapsed and was renewed in September of 2024. While the pharmacy uses a 2-step license verification system, the technician was an internal transfer that did not follow the normal onboarding process. Counsel stated that the technician mistakenly believed that renewing her PTCB certification also renewed her state technician license. The technician had indicated in her statement that she had transferred to a technician role in February of 2024. So she worked approximately 144 days under an expired license. Once she realized that her license was not renewed with her PTCB certification, she quickly submitted the renewal application. Counsel also indicated that technician SC moved to Arizona in August of 2024. She worked remotely from the Arizona location, although not in the facility. She performed work for the Ohio location through the Ohio Pharmacy Management System, as she was a licensed technician in Ohio. However, she was performing those tasks while located in Arizona. And she worked for 77 days while located in Arizona before she obtained her Arizona license.
Thanks, Mr. Wagner. I'm sorry, Mr. Rain, I didn't have you and your compatriot introduce yourselves. I don't know if any of the technicians named are online either.
Believe they are available. Stephanie's available. Oh, she may be online. Miss Cowdrick is available online, we believe. Miss Mogaka will not be, unfortunately. But please introduce yourself.
My name is Rob Flegging. I am the current PIC and pharmacist manager at Costanoa, which is doing business as Phil RX.
I'm Michael Rain with Bozen and Snow on behalf of Phil RX.
Do you guys have a statement?
Yeah, just a couple points. I know you've read our materials. One of the main clarification or points that we'd like to make is that as to Ms. Mogaka, the technician with the lapsed license, Phil did identify that internally and worked to correct it before this matter arose. We provided information to the board to indicate that she had only accessed the pharmacy management system on 3 occasions during the period of her lapse. She was, though, working for Phil, I believe, within the facility at that time. So, we recognize the oversight of the lapse. We did describe Phil's pretty robust process of vetting initial new hires to make sure that they had appropriate licensure. And this was just an out of the ordinary way for her to get into this position, and it did slip through the cracks. She subsequently reinstated her license, has kept it in good standing ever since, and she provided a letter describing her error. It should be in your packet. As to Ms. Cowdrick, the other technician, we provided evidence that, yes, she resided in Arizona for the period of time that was mentioned, but she never accessed the Arizona pharmacy management system. She was only working on Ohio issues. She was a current Ohio technician licensee. During this process, however, she did apply for and obtain an Arizona technician license, just to have that in place. I know that the board has discussed this issue before, but she was not practicing pharmacy for Arizona pharmacy clients at any time. There's no allegation that she was, but she was just physically present in the state as a technician doing technician work for Ohio patients for the Ohio location of Phil. But again, she was able to obtain an Arizona technician license so that that would not be a concern any longer. There was some discussion of the security. Of course, PhilRx denies that the pharmacy lacks security. It met the minimum security requirements when it obtained its permit from this board. There's no allegation whatsoever that any unauthorized person has ever been allowed in the pharmacy space. You know, there was an issue with the badge reader on the entrance to the pharmacy that Phil has since corrected. They've added a separate badge reader on another door. There's a third entrance to the pharmacy that's permanently sealed. It is a non-dispensing pharmacy. It's not, there are no walk-ins. It's not that sort of environment. We do want you to understand that about PhilRx, which is a hub. But we hope that the board sees that, you know, Phil has taken corrective action to make sure that, you know, the pharmacy's badge readers on the doors are active and in good working order to prevent any unauthorized person from entering the pharmacy if that was to occur. But with that, you know, we hope that the board will review the mitigating factors here and consider resolving this with non-disciplinary penalties as your rules contemplate for lapsed license work for Ms. Mogaka. We candidly don't see a violation per se on the security issues. They have met all minimum security standards, and there's no allegation of any unauthorized person in the pharmacy to violate that particular rule. And so we're not sure that there's a basis for discipline on that, but we're happy to discuss the security of the pharmacy with you today. And Mr. Fledging is here today, should you have any questions.
Any questions from board members?
I have a question. So when you are operating during the day, anyone could enter correct? Once you unlocked the door, it was unlocked all day. So if I wanted to walk in and I wasn't employed there, I could just walk in.
Currently, no, but at that time, you may have been able to. Yeah.
Okay. So I do have a concern about that level of security for HIPAA violation purposes, if not for medication purposes. And I have a question. Once you heard those statements about the technicians, do you still agree with the amount of days they worked without a license?
And that may be a question for legal counsel, but the technicians were performing technician duties regardless of whether it was for Arizona patients or Ohio patients within the boundaries of Arizona.
I don't know if you have a definition for this, but if somebody working remotely for a different state and we're not aware of this licensee or technicians, can we track that? I don't know. Like, I don't know how many technicians we have in the state of Arizona working remotely for other states. They're not touching any Arizonan.
And that is a
medications.
practice of pharmacy and technician duties. So they should notify us and be licensed in our state if they're practicing in our state.
Okay, so that's considering practicing in our state, even
They
they're
are
not.
practicing
Okay,
in our
yeah,
state.
just about the security item. So, do we have definition of minimum security required for our permits or pharmacies? And do they meet this minimum?
The facility is supposed to be secure from unauthorized entry, which also includes a technician can't be in there without a pharmacist being present because that's an unauthorized entry.
And if I could add a little more description, so the entire suite is considered the pharmacy. So once you open the door and walk in, you're in the pharmacy. There's no boundary inside the suite that would prevent you from going anywhere within the suite. So when I arrived there on the day of my visit, I could open the door and walk right into the pharmacy, or what was considered the pharmacy. As Mr. Rain said, it's a non-dispensing pharmacy. There's no drugs on site, but there are terminals and and individuals working within that space.
So when we give them like the permit, right? So they went through inspection,
Mhm.
correct? So did that change since the inspection, or the same security they had before and they kept doing the same thing?
I don't recall when I did the opening inspection. I know they had locking doors.
Okay.
That at the time, they could have just kept those doors locked and not permitted entry into the pharmacy during working hours. But that was not the case when I visited the
Yeah.
pharmacy.
So, but I mean, nothing changed like in structure of the interest, nothing
No.
like remodeling without us knowing. Yeah.
Do you have any reason to believe that between the time of the complaint and the time that you were physically there and walked in, that there might have been security? Or to say it differently, do you think that anybody could have walked in between in that 2-week period?
Yes.
What does security look like today?
Our basic security would be, as you mentioned, a pharmacist has to be there at all times, and there are locking mechanisms. So there have been times even during that period where we would physically lock it, and if we were to go to the bathroom, we would physically unlock it, go to the bathroom, come back. But there were like when Mr. Wagner came, it was not locked at that time. Currently, the doors still have that locking mechanism, but we also have a badge reader that each person has a badge. And if, for example, I were to not work there anymore, we would remove access from that badge. So even if they tried to use that card, if they weren't able to return that card, it would flash red and they would not be able to enter the pharmacy currently.
How long was that badge reader not operable?
I am unsure. It was operable, but there were intermittent periods where it was not. So we would actually like physically lock the door, but there were periods where we did not in that moment.
How long did it take before you could get it repaired? The card reader.
From that moment?
Yes, from the moment you saw, how long did it take them to get in to repair it?
Well, once Mr. Wagner came, we were able to fix it immediately, basically.
So how long had you known that it was not working?
At the time, I was not the PIC, so I'm not sure of the exact timeline, but so I can't really speak.
Where
to
I'm
that.
going is, why did you not physically lock the door and order it to be repaired and have it unlocked when he walked in, or anybody else for that matter?
Yeah, I believe the fact that they don't have medications inside, they maybe overlook this.
But they still have.
Yeah, I agree. I agree.
documents
Yeah.
that are privileged.
We are a paperless pharmacy, so we don't have.
You still have documents that are under HIPAA control, so whether you have pharmaceuticals in there or not, it doesn't matter.
Mr. Wagner, I'm thinking about security in a community pharmacy that dispenses medications, like a drugstore that patients walk into. And it's considered to be secure if there's even just like a half swinging door to enter the pharmacy from, say, their cash register area. So can you talk about like that being sufficient for security in a dispensing pharmacy versus what was happening here?
Well, a swinging door would still have to be latched and require some type of manipulation to open that door. You couldn't just walk through the door.
But no key or badge would be required to be sufficient for security at a retail pharmacy.
Correct.
Ms. Davis, if I may. You're touching on the exact point that I was going to make, which is your minimum security standards require locking mechanisms. And that's where it ends, that they can be locked. There's no dispute that this door could be locked. It would be secured at all times that a pharmacist wasn't present. You don't have a rule that says it needs to be locked during the day when people are inside. That rule does not exist. There's some rules about further security for drug products and locking. But as to the physical security of the pharmacy, your minimum standards require the ability to be locked but there is no requirement to have badge readers at all, no discussion of that at all, and no requirement that a pharmacy remain locked while it is open and a pharmacist is present inside. Nevertheless, we don't want to discount that Phil is happy to keep that locked pretty much consistently throughout the day. The badge readers allow them to do that without much inconvenience to staff, and they have those in place. Mr. Fledging can also discuss the security at each terminal. You know, as a paperless, non-dispensing hub pharmacy, they recognize terminals can still have information on a screen, but if you're interested, we could talk about that level of security, which has multi-factor authentication, biometric security, automatic timeouts if someone walks away from their desk, things of that nature.
Why did you have the badge reader repaired? Why did you get it operable?
It was always there. It wasn't operable in that moment. So we just went ahead for security reasons after Mr. Wagner's concern, and we made sure it was a concerted effort to make sure it was always functioning and easy to access for employees. But yeah, at that time it was just because we felt it was the right move.
I guess my point is, if you don't think that it's needed, why would you have it there? Like, if you think that it's a security measure that's appropriate to your place of business, then why not have it be operable?
That's a fair question. At the time, again, I was not in a leadership position at the company, so I can't really speak to it at the time, but it is definitely something we take seriously, even whether it's HIPAA or just people security of a former employee, things like that. Even if we were not a pharmacy, I feel like that has become a good practice for us. So we feel comfortable with our security now, and I feel like it's more than we need, I think, but we feel comfortable with where it's at now.
I believe, Mr. Wagner shared his concerns at the time, I believe, of the inspection, and there was a willingness to address them.
Question, what's the state law with regard to, and the rules regarding keeping something locked or access to it? I mean, if you can have a lock, but if you can still open the lock at any time, open the door at any time, whether it's locked or not, that doesn't seem like restricted access. It seems like walking into this room. What's the law requirements on that?
I am not sure I understand the question. So
Let me rephrase my question. If a pharmacy has to be secure, or where HIPAA documents have to be secure, what does the term secure mean? Does it mean that you have to have that door locked or that entrance locked so nobody that is not licensed can not go into that room? Or does it mean you can leave it unlocked? And what does it mean?
Yeah, go ahead.
I would have to look into that.
So just by the time she looked at it, if we were talking about HIPAA here, it is the federal rules, and you're required to have a physical guard and software like protection as well. So you need to have both, right? So I don't think there's a definition from my perspective how you protect it, like physically, from people physically access the documents, but you're required to protect those.
Well, that's, I think, the core of what we're getting at here. If the door is unlocked and it's not physically being locked, whether it has a lock on it or not, is that appropriate? And that's the core question here. And unless we have the answer to that from a legal perspective, how do you rule on it? That's where I'm going.
When the pharmacy is closed, it would obviously have to be locked, or when a pharmacist wasn't present, it would have to be locked.
Exactly. And we have an alarm as well.
But the fact that it's able to be locked would technically meet the requirement of security.
Well, if I may, R423-610B2 states that a pharmacist employed by a pharmacy shall ensure that the pharmacy is physically secure while the pharmacist is on duty. Now, if I walked to the door and could push it open without having to unlock the door or do some kind of mechanism, then is that physically secure?
That's the point I'm trying to get at.
Okay, from this perspective.
But if you were to try to get behind the counter at a chain drugstore and all you had to do is click a little latch open, is that physically secure?
Subjective.
And Ms. Davis, if I may, I don't disagree with what Mr. Wagner is saying, that you have a rule about minimum security standards that require it to be lockable. And of course, you have your laws about needing a pharmacist present if anyone's going to be in there. And then you have a rule that says physically secure is more of a subjective concept. All of those exist. I think.
So, yeah, I mean, like, I believe that the case, we have two different violations here. We have the working without valid license for 2 employees, and we have the security issue here on the same complaint, which is make it difficult for me to do 2 different motions for the same complaint number. From my perspective, I believe the security, they fix the issue, they address the issue is overlooked by management. Then it's a concerning, you know what I mean? I will be more concerned if there is a drug there. I mean, the fact that the software, I hope, was like secured, like people have those kind of minimum secure features for the software itself. I would be like, and I believe it's secured now, right? They have everything, they meet all the requirement. I will, if this is a separate case, I would be satisfied with the letter of concern for them. But the other item is working without valid license for 2 technicians. That would, I believe, we need to discuss further.
I'm ready to make a motion on that.
On the whole case, yeah, go ahead.
All right, I'll do a letter of concern regarding the security measures now that they've been addressed, and I feel a little more confident about it. $300 non-disciplinary fine for both technicians and a $1,500 non-disciplinary fine for the permit holder for working without proper license.
Okay, I have a motion. Would anyone like to make a second? All right, any other discussion? Oh, yeah.
If I may just be heard on the motion, your rule about non-disciplinary civil penalties applies to both permittees and licensees. And I just wanted to draw your attention to that there is a cap on that amount. I believe it's not to exceed 500, but I was just trying to pull it up for your
I
reference.
think Ms. Snare took her dollar amounts from our standard terms for working without a license.
So it's 1,500 for permit holder, that's a max, and $300 for each technician, that's a max. And I believe, considering the number of days that they already meet the max, and that what she rolled on.
I mean, I don't think that you're taking an unreasonable position or anything with the number. I mean, but I'm looking
Ms.
at.
Galvin, do you have any suggestion there?
And I'm looking for, if it's of any help, it's your rule 90210, failing to renew a license and continuing to work on an expired license as to at least Ms. Mogaka, pharmacy technician, $50 a day worked, not to exceed 500. And there are 2 of them, essentially.
I think she was assessing the non-disciplinary civil penalty on both technicians separately.
Yeah, that would get us to 1,000 though. I thought it was 1,500.
She offered 1,500 for the permit holder and then 300 each for both technicians.
Okay, so just make sure I'm following you. I'm not trying to be difficult. So it would be like 3 $500 non-disciplinary civil penalties for the permittee because you have 2.
1,500 total for the
Oh, for
permit.
everything combined. I'm sorry.
Yeah, 1,500 for the permit holder, that's done for and then 300 for each technician.
Well, then that brings me back to
The technicians license, their $300 non-disciplinary fine
I hear
for
you.
each technician to pay on their own. And then $1,500 total for the permit holder, non-disciplinary.
And just to make sure I'm on the same page, the reason it's 1,500 for the permittee is because you have 2 technicians and
I mean,
I don't know.
I would move to 1,500 for each violation, but since it's a one case, because I believe, I can be corrected, please, if I'm wrong. In this, the violation is working without valid license. So even expired lapse or not licensed at all, right? So, and what we're rolling with is for permit holder, it's 50 per day, not to exceed 1,500, right? And that what we voting for. It is 50 per day, not to exceed 1,500. So this is part of her motion is 1,500 for the permit holder. Like,
I've pulled up your rule from your current website.
no, it's good to be corrected if I'm if I have a
can make it
wrong.
$750 per technician. That
So I
you think it's
Mr.
500?
Rain, if I may, I'm sorry. The one you're reading is about renewing your license and working after failing to renew, right? These individuals never had a license to begin with.
Well, no, one did.
One did?
One did.
Okay.
But what is the citation for the 1,500 in the rule? Or is that like a guideline?
That is a guideline. So
That's
it's not.
probably
it's
the
not-
source of
Yeah,
confusion.
it's not itemized in that.
I don't want to
section you're
labor it
reading.
anymore. I wasn't
So Ms. Nair, can you modify your motion to work with the staff about the fine since it's not disciplinary, so they can make their math?
So I think Ms. Snare is on the button. For instance, R 423-902-10B caps it at 500 for technician, and it's 300, right? So it is well below the maximum. And then we address pharmacists, but we don't address permit holders in that section. And that's based on our guidance document that you created many years ago.
But I would disagree that you don't accept permittees under the leading language under Rule 902. It says, as authorized under 32-1904D, the board may issue the following non-disciplinary civil penalties to a licensee or permittee.
But number 10 specifically itemizes registered pharmacists and pharmacy technicians.
I understand, but I believe you, for what it's worth, my legal argument would be you can impose that non-disciplinary permit violation on the permittee, but you've been more than thoughtful in your deliberation. We're okay with your motion.
Okay. Normally I would include the PIC, but they're not listed in the complaint. So I didn't go that way.
Okay, we have a motion and a second, I believe.
Yes.
Okay, all those in favor?
Aye.
Aye. Any opposed? Thank you for being here
Thank you
today.
so much.
Thank you.
Madam Chair, I believe Ms. Wamsley has joined the meeting, so you can wipe the sweat off your forehead.
I'm here.
Welcome back, Ms. Walmsley.
Hello. Do you guys want to take a quick break or are you guys good to keep going?
Depends on how you feel. I know that you wanted to see where we're at, and I communicated which ones we
Yep.
got through. So if you want a recap, we're happy to take a break, or if you feel good.
I think I'm good. So it looks like we're gonna pick up at 9B. Is that right? Am I following the train of thought here?
11A, Madam Chair.
Did you already do 9B?
Yes, we did.
Okay. So 11A.
Yes.
This is a non-resident permit requiring board review, Millers of Wyckoff. See Mr. Hyber's coming up. Do we have anybody on the line from Millers of Wyckoff?
Hi.
Yes. This
Hi,
is
if you
Philip.
could please introduce yourself for the record.
Hi, my name is Philip Regadundon. I'll be serving as the pharmacist in charge for Millers.
Awesome. Mr. Hyper, if you could give us a brief summary.
Good morning, board members. Steve Hyber, Compliance Officer. The board received a non-resident pharmacy change of ownership application from Millers of Wyckoff. And their location is in Wyckoff, New Jersey. During the initial permit review process, it appeared that there was some undisclosed discipline. It was undisclosed. After substantive review, we did find undisclosed discipline, but that was on the current permit that the pharmacy has. It wasn't disclosed during the last 2 renewals of that permit. And but the majority of the disclosed discipline on the permit application was over 5 years old. But I did list 2 disciplinary actions, one by Hawaii, a fine, and another by Tennessee. And the substantive review also found that the board had received written notification of a pharmacist in charge change from the actual pharmacist in charge, but then the board profile, when it was updated, it had a different date of when that pharmacist in charge occurred. So we had about a 16-day gap, it appeared, with that pharmacy operating without a pharmacist in charge. And then the only reason I bring a lot of this forward, since a lot of it's on the current permit, not on the applicant, because obviously the applicant's new, one of the officers we found that's listed on the new permit application is an officer within the current permit. So there was some linkage there that, you know, we felt that the board had to have the opportunity to review this application. Thank you.
Thank you, Mr. Hyper. Philip, would you like to make any statements before we proceed with questions?
No, I have no comment at this moment.
Thank you. Board members, discussion or questions for either Mr. Hyper or for Philip?
So my question is it reasonable to link the behavior of the previous licensee, since the ownership now is the same under the current, and is that reasonable to do that?
It looked like the CEO or president is also with both the old and new company.
So as the board, we may have concerns that the behavior under the previous might indicate continued behavior of a similar nature, given that the ownership is similar in some ways.
I mean, I'm not personally overly concerned about the facts of the discipline, it looks like. I'm just at this point concerned with the non-disclosure is where my head is.
I agree. I'd be willing to make a motion unless there's other conversation. I'll make a motion for a $250 non-disciplinary fine.
Second.
For failure to notify.
I think we had 2 failures to disclose. Okay, that's fine. I could do that times 2.
I'll amend my second.
I have a motion and a second. Any discussion?
I'm unclear on what the 2 items are. I'm sorry.
They didn't disclose the discipline.
Right. Okay, got that one.
In 2022 and 2024.
Okay, no concerns about the pick.
It wasn't done timely. We could take action on that. I was just doing the failure to notify.
Thanks.
Because it wasn't like they didn't have a pick for us. That was the basis of their discipline. And the other state that they didn't disclose. Any other discussion? All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Thank you for your attendance, Philip. Thank you, Mr. Hyber.
Thank you.
Neil, I'll give you the next
Sure.
2 because I'm recused on those.
All right, tab 11B is a non-resident permit application for Walgreens number 11674. Welcome, everyone. Will you please introduce yourselves, starting with Ms. Chang?
Good morning, board member Nancy Chang, compliant officer. On January 7, 2025, Walgreens 11, store number 11674, applied for a non-resident pharmacy permit with the Arizona Board of Pharmacy. The applicant didn't disclose that the pharmacy had a citation from the home state Utah Board of Pharmacy. The pharmacy had a high number of expired medication on the shelves during the Utah Board inspection on May 2nd, 2023, resulting in a fine of $1,250. A copy of the citation is included in the package for your review.
Good morning, board members. Susan Trujillo from Quarles and Brady. On the line, we have Mike Simcoe from Walgreens Corporate and Holly Prevo, who is the healthcare supervisor for the Western operations. And so she'll be able to speak to the pharmacy specifically.
Welcome. Would you like to make a statement, please?
I'm happy to make a brief statement, and then they're available to answer any questions that you may have. Walgreens, of course, would like to assure the board that these omissions were not intentional and based on some incorrect information that the licensing staff received from the pharmacies. Walgreens has looked into this matter and identified areas for improvement, such as ensuring that Catherine Pavlik, who's the licensing staff member who completed these applications, has access to the pharmacy discipline data bank so that she can obtain historical information for the pharmacies going forward. Walgreens apologizes for causing any confusion or delay for the board staff, and we're here to answer any questions that you may have, both about the application and then the underlying discipline.
Does anyone have any questions?
I don't think it's deviate from other violation, like fail to report, right? So I am ready to make a motion for $250 fine for failing to report discipline action.
Second.
Okay, I have a motion and a second. Any other discussion?
And that's non-disciplinary?
It is non-disciplinary, yes.
All right, all those in favor? Aye. Any opposed? Okay, let's move on to 11C, non-resident pharmacy permit for Walgreens 7052.
Nancy Chang again. On January 7th of this year, Walgreens store 7052 applied for a non-resident pharmacy permit with the Arizona Board of Pharmacy. The applicant didn't disclose that the pharmacy had a citation from the Utah Board of Pharmacy for violating the controlled substance inventory records keeping and the pharmacist to technician ratio, which resulted in a fine of $1,050. The annual controlled substance inventory records for 2019 through 2022 were unavailable during a random inspection by the Utah Board of Pharmacy on September 20, 2023. The Utah statutes regarding the pharmacist to technician trainee ratio does not exist in the Arizona Board of Pharmacy laws and would not be a concern of the board.
Hello, board members. The same statement and same representatives here apply, so we're available to answer any questions.
I have the same motion. It's exactly copy the same previous. So I move for $250 non-disciplinary fine for failing to report a discipline.
I have a motion. Would anyone like to make a second?
Second.
All right. Any other discussion? All those in favor? Aye. Any opposed? Thank you for being here today.
Thank you.
One quick thing on actually the last three items. I think we also need to actually make a motion to issue the permits for all three. We didn't do that with Miller's of Wyckoff either, I don't believe.
So
Um,
same on 11B and 11C?
which I'm recused from.
Oh yeah, okay.
Let's do A separately, and then you guys can do the other two with me off.
So do we need to modify the previous motion or we make another motion, separate motion?
Miss Galvin, how do you want us to handle that? I just want to make sure that we're clear that we wish to issue the permits after payment of the non-disciplinary fine.
And that's my motion, yeah. I approve the application upon paying the fine.
Second.
Motion and a second for approval of the license under 11A. All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Ms. Davis, if you could do the 11B and 11C.
Sure. Would anyone like to make a motion to approve the non-resident pharmacy permit for the Walgreens 11674 and 7052? Upon payment. All right, I have a motion. Do I have a second?
I second.
All those in favor? Aye. Any opposed? All right, Ms. Walmsley, back to you for 11D.
Awesome. This is a non-resident pharmacy permit application, High Creek Pharmacy. Is anyone present from High Creek?
Yes, we are. Danny
could-
Robbins.
And what's your role, Danny?
I am the pharmacist in charge that was working with Mr. Wagner. However, we have since switched, and Michael Baer should be on as well. He's the current pharmacist in charge.
Yes, I'm here as well.
Thank you. Mr. Wagner, if you want to give us a brief summary of the application.
I'd be happy to. Have my head on a swivel trying to see you and everyone else. Yes, this was a change of ownership application for a non-resident pharmacy permit. The applicant disclosed a pending disciplinary action. The discipline was imposed after the application was submitted. The discipline from their home state of Utah for the pharmacy included a $25,000 fine and a probationary period of 5 years. The inspection occurred in September of 2024 and resulted in the discipline was conducted under the previous ownership and previous pharmacist in charge. Although the permit is under probation, the previous ownership and PIC are no longer involved in the ownership or operations of the pharmacy.
Sorry, take myself off mute. Thank you, Mr. Wagner. Mr. Robbins, Mr. Baer, would you like to make any remarks before we proceed with questions?
I do need to interject that the Elliott and the ownership of Lauer Foods, Elliott as former PIC and former ownership did exit from the company, but Lauer Foods, who at the time was 50% ownership, is now 100% ownership, are still very much involved in the pharmacy. So just a slight correction that Elliott, the PIC at the time of September when the audit took place, is no longer with the company and his ownership is no longer with the company, but the other ownership partner is now 100% owner of the company, and that is the case moving forward. But they have no managerial control. The managerial control relies with me as the PIC.
Have you had any follow-up inspections from the Utah Board of Pharmacy or any, surveillance from them?
Yeah, so after the inspection was conducted, we met with the board on an ongoing basis for every month since the beginning of the year, and then it's now been converted to every 6 months. The state required that we had submitted a self-inspection by no later than May 30th, 2025. We actually conducted the self-inspection on May 2nd of 2025 and submitted to the Board of Pharmacy on May 5th and convened once again with them in June post self-inspection, in which the Board of Pharmacy did accept the current status of the pharmacy and moved to put us to only having to meet with them every 6 months. That we're still under probation, but they did rule in that we were in good favor with the state and ensuring full compliance and making patient safety our number one priority.
So using your own word, what's the nature of the discipline and what you have done since then, like since you took over the management there?
So the full compliance was additional training. We invested lots of money in being able to do additional training for the technicians and have included and updated our SOPs since I've taken over to be able to do internal audits with the inspection form on a quarterly basis, aside from just doing it biannually as required by the state, but to do it more frequently with the technicians on a quarterly basis and keeping those recorded digitally at the pharmacy to ensure that the pharmacy is not only in full compliance, but that we can show the state that we're conducting those internal audits and updating the quality assurance checklist, which was done on a daily basis. There was just some identified holes post audit that allowed us to increase the amount of quality assurance control that takes place on a daily basis as well.
Have you updated your labels?
The labels have been updated. Yes, they were updated the next day after the audit took place.
Knowing that they're being monitored by Utah and the individuals are not involved anymore that were the issue, that were performing the misconduct, I don't have a lot of concern with this one, especially given the fact that they are being monitored and have to report to the Utah board on a pretty regular basis. I'm comfortable with moving forward with approval on this one and not doing any type of reciprocal discipline on the license. Where my head is.
Sounds like they've taken a lot of good actions that are favorable, so I'll move
Yeah.
to approve the application.
Second.
A motion and a second. Any discussion? All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Thank you both for being present today.
Thank you.
Thank you.
All right, let's go to 12A, Rightway Medical.
I'm sorry, would that also include granting the application?
Yes.
I thought that's what we were doing is approve the application. So we're
You said that-
approving.
Okay, I took that as different, but okay.
Okay. If you need me to state it a different way, just let me know.
No, I think the record would be clear.
Okay.
You just said take no action, so.
No, I said approve the application.
Oh, I'm sorry then.
Oh, that's right.
All right, Rightway Medical, is anybody present for Rightway?
Right now?
Madam Chair, I can speak to this one. I believe in your,
Okay.
you have an agreement that Rightway Medical and myself came up with to resolve this matter. I believe there was some shipments into Arizona, and that's the only deficiency with this application. And we basically had a discussion of our customary settlement with them.
And we have a we have a order or consent agreement already, right?
Let me just take a look.
I think we have an agreement.
Correct. It's in the board book.
Okay. So an appropriate motion would be to approve the agreement and potentially issue the fine upon issue the permit upon payment of the fine.
That is correct, Madam Chair.
I'll make that my motion.
Second.
Motion and a second. Any discussion? All those in favor? Aye. Any opposed? Hearing none, motion carries. All right. 13A, Select Consumer Group.
Yes, we're here.
Hi, if you could please introduce yourself for the record.
My name is Alex Bromfield, licensing specialist.
And I see we have Mr. Castaneda and Mr. Jacobson. Would one of the two of you like to give us a brief summary of the application?
Yes, thank you, Madam Chair. Max Jacobson, Compliance Officer with the Board of Pharmacy. Select Consumer Group and Select Corporation appear to have a relationship. And what happened was Select Corporation held a permit with this board and allowed that permit to expire. Did it start working again?
All right. Mr. Brumfield, would you like to make any remarks?
Madam Chair,
Yeah.
I think the mic's cut out there for a second. We're just letting the technology catch up for a second.
Okay. Sounds good. Thank you.
We're good to go?
I can hear you fine.
I can hear him as well.
Okay, I think we're back on here. Okay. So I was just saying that Select Corporation allowed their permit to expire. Select Corporation had discipline with this board for shipping products into Arizona without a license. So what happened, or what we found during substantive review, is that both the manufacturer and the wholesaler permits that are being applied with for Select Consumer Group, although the company says it's not a change of ownership, to us it looked like a change of ownership. It looked like they allowed one permit to expire and then applied for another permit to get around that discipline following their permits. Furthermore, based on communication with the company after the substantive review was completed, it's not clear which permits the business requires. The company performs repackaging, and the designated representative stated it also may be shipping products in a manufacturer's original containers, which would require a wholesaler permit. However, the company does not hold a wholesaler permit in their home state, and therefore they would not be able to hold a wholesaler permit with us, a non-resident wholesaler permit. Some of the things that the Select Corporation and the Select Consumer Group, which is the current permit, had in common include the designated representative is the same person, the address is the same person, the business model is the same, and it seems that the employees are the same. So although they claim it's not a change of ownership, it sure appears that it's a change of ownership to us. Ben?
The only thing, sorry, Ben Costantino, the compliance officer, Arizona Board of Pharmacy. The only other thing additionally I would add is that I asked the same questions during the substantive review of the manufacturer permit application as Max had asked, and the results were consistent. They maintained that it's not a change of ownership.
Mr. Brumfield, would you like to
Yes.
say anything before we start with questions?
Yes. Well, so our home state, the state of Texas, did not require a change of ownership when we applied for the manufacturer's license. So that's why I kept it consistent. And then when we applied for the Arizona one, it was like, for a change of ownership, we needed like a bill of sale, but there was no bill of sale. There was no documentation of a sale, of a transfer of ownership. So that's why we decided to move forward with just a new application. We were not trying to circumvent anything from a previous board order from Select Corporation. We were just trying to follow the way our home state did it, and compounded with the fact that Arizona wanted a bill of sale. It was some type of documentation they wanted to do a change of ownership, but we didn't have that documentation because that didn't actually occur on paper. So this is a closely held family-owned business, both of them. So it's not as if we're trying to totally disassociate ourselves from one another. It's just that in the state of Texas, it required us to apply for a new one, since there was no stock exchange, there was no actual money exchange for the business. So that was the only reason why we started a new application, along with the fact that we wanted to be more compliant than we were previously. So we weren't trying to like do something nefarious, if that makes sense.
What
Can you
prompted this change? So if you didn't change ownership, what made you reapply as a new applicant?
Because the son actually opened a different company. So Select Corporation was fined, I think, I'm not sure what year it was, I wasn't employed at the time, but they were fined for not having a license originally, a wholesale license. They got the wholesale license. That had been resolved. They paid their fine. So I'm not exactly sure why the son didn't buy the company from the father, or, I don't know the reason for that, but I do know the son wanted to open a company himself instead of taking on and purchasing the company from the dad, which the dad allowed him to. So he opened a new company, Select Consumer Group, and with the Board of Pharmacy of Texas. And then from there, we were going to go to Arizona and the other states to get a manufacturer's license. And another part too is the state of Texas, when you have a manufacturer's license, it allows you the same things that a wholesaler can do, the manufacturer can do. So it's not required to have a manufacturer's license and a wholesale license. If you have a manufacturer's license, it's viewed to be a higher license than the wholesaler license or distributor license, as they call it in the state of Texas. So we weren't trying to do anything wrong other than be more compliant with getting registered Select Consumer Group as the proper designation as a manufacturer. And that was found out after we applied for the wholesale license, after I think I was emailing with Max, if I'm not mistaken, and like, well, you all need this license. And we're just doing OTC products. We're not doing like actually prescription products. So that's where I turn around and we apply for the actual manufacturer's license.
So can you tell us a little bit about your business model? There was some confusion about whether or not you applied for the right type of license, if you're repackaging, et cetera. Can you clarify a little bit for the record what you're doing?
Yeah, so basically we sell to, our primary customers are gas stations, and we sell like deodorant, toothbrushes, dental floss, Claritin, Benadryl. We sell those products. Now, there was some confusion about whether or not we should be a manufacturer, because I don't know if you consider this repackaging, but like that product that's in there, that's directly from the manufacturer. What you see in there, we just put it inside of this package. So I felt like, well, okay, let's just be more stringent and just say we're a manufacturer, because when I was emailing with Max, it was some unreadiness, some confusion about it. So I was like, okay, well, if that's what they're saying, that's what we're going to do. And then I know, so I don't know if it's considered, I didn't feel like personally it was repackaging or we was a manufacturer, but since the outer packaging was a different package other than what you see in there, which is the original package from the actual manufacturer, I was like, okay, well, we'll try to be as compliant as possible. But I feel like we really just need the wholesaler license. I don't think we needed the actual manufacturer's license. So I was following the guidance and the email that I was getting from the representative from the Arizona Board of Pharmacy when we applied for the manufacturer's license. I hope that clarified for you. I can't hear you, Lori, if you're talking.
I was thinking, Mr. Castaneda, Mr. Jacobson, do you have any follow-up questions for him on? I don't know that I'm still clear if he's applying for the right license.
Sure, if I may, board members, if you could go to page 2653. About halfway down is what the email chain is what led to my confusion about what their business model needs for a permit in Arizona. Because he does state on Wednesday, May 7th at the 9:54 a.m., we do have products that are in the original manufacturer's containers that are non-prescription. So maybe we need some clarification from him exactly what they are repacking and or shipping.
So I'm just going to open this up right quick. So inside of this package is what we get this from the manufacturer. We simply put it in here. You know, you walk into a gas station, you see these little, these little boxes here. We put it inside of this box, but this is the original one. So we never open the actual product. There's no pill. We don't repackage the pills and put them in a sachet. We just put it inside of here. So, and it was somewhat confusing to us. So that's why I was like, okay, well, we're just going to apply for both. And we'll go from there. Like I say, in the state of Texas, if you have a manufacturer's license, you don't need a distributor's license.
So if you go back to the package you have, when you put it in the new packaging, you're covering some information, right? Like you're covering the
that's
warning true. Or whatever, right?
Well, we do, but it's on this package now.
So you did this, right? So
yeah.
You create this outsider, right?
Yes.
You are manipulating the original package to make your own package, and this is my personal opinion, you know what I mean? And I believe that
I can't hear him.
Yeah, I can't hear either.
okay.
Still can't hear him.
Can you hear me? Okay. Where did I stop? I'm just kidding. So I believe you manipulating the original package, and to me that's considered repackaging because the package is yours. That what patients or customer can see on the shelf is what you wrote, not what the original manufacturer. From my opinion, I'm not a FDA expert here. I mean, I have some knowledge. So I believe you're repackaging, and that will go under manufacturing, right? So you need, from my opinion, you need manufacturer license.
And I agree with that as well. So that's why we went ahead and we applied for the manufacturers. After Max, the email exchange with Max, I said, okay, well, let's just apply for the manufacturers. And that
Yes. So just to make sure that I believe for manufacturer is the right application. That's in my opinion.
Yes, board members, and if I can interject as well, they do have an OTC manufacturer permit in their home state, and under modifiers it says repackager, relabeler.
Great. So
correct, but they do not have a wholesale license or permit in their home state.
Do they need a wholesale permit for what they're doing for us?
We may need to do some research on whether the Texas board would allow them to wholesale products or ship products for a different manufacturer. The manufacturer permit might allow them to distribute their own manufactured products, but we'd have to double check to see whether they would be allowed to ship other manufacturers' products as a wholesaler with that manufacturer permit.
And they do. I mean, you obviously, I'm sure you guys will do your due diligence, but they do. With the state of Texas, that's not with the Board of Pharmacists, with Texas DSHS, Department of State Health Services. Any rights that a wholesaler has or distributor has, the manufacturer has. The only thing is the manufacturer can manufacture in addition to all of the other rights and privileges that distributors have.
So the thing that we're coming across here is that Arizona rule dictates that the non-resident permit applicant hold an equivalent permit or license in their home state. A wholesaler permit in Arizona doesn't allow a manufacturer to distribute on behalf of another manufacturer. So that's what the problem is with this situation, is that if in fact they are able to distribute products for other manufacturers with their own manufacturer permit, then we would need to have that documented properly so that we can issue this permit without them having a current equivalent permit to a wholesaler permit.
So yeah, I mean, so they do repack. Their manufacturer license is limited to repackaging, right? Every time I talk, I believe there's something wrong with my voice, I believe. So okay, so their license is for limited to repackaging and relabeling, correct? The manufacturer.
I can't speak to.
Is it? Yeah, just to make sure. Their manufacturer license is limited to repackaging and relabeling, or it doesn't matter.
I'm not sure. Is that question for me?
I mean, yeah. I mean, can you answer the question? Your manufacturer license.
The Texas manufacturer license type is OTC manufacturer. According to them, that allows them to distribute other manufacturers' products as well, and that's not how it works here.
Yeah, but that's my concern. If there is inside the package, sort of manufacturer never has a license in Arizona, you know what I mean, or not authorized to ship to Arizona, so they can basically use their license and ship it to us. and I see it an issue, right? Like, if so, I believe we need the clarification here. I mean, like, more details about what they're doing.
Generally, during administrative review and substantive review, if there's a question of whether their home state permit does offer the permit that they're trying to get with us, we have the applicant contact that entity and have them provide them with some sort of written documentation that they wouldn't be given a permit for their business model. So we're gonna have to go back to the Texas Department of Health and get that information. We can have the applicant do it. Generally, we have the applicant provide that information, just like we would have them provide a copy of their home state permit.
Correct, yeah.
I have a question. You all did say that as long as the home state has an equal license, which is the wholesaler permit in Arizona, so as long as the manufacturing permit in Texas allows for me to distribute, for Select to distribute other manufacturers' products, that will be considered an equivalent license, correct? And we would not be required to have a wholesale license, am I correct?
In theory, we would be able to issue both a manufacturer permit and a wholesaler permit with that.
Okay, theory. So basically, I just need to get the information from the Texas, from DSHS, stating that we are able as an OTC manufacturer to purchase product and sell other manufacturers' product, which essentially act as a distributor as wholesaler in the state of Texas. And then Arizona's position would be that we will be able to get issued both licenses. Is that correct? Permits, I'm sorry.
I believe we need clarification. What's your limitation? I mean, what scope of practice for your manufacturer?
I don't think that there's a.
That's what we need to know, because I don't want it. I don't want something to enter state of Arizona just because you repackage this and you authorize to do that in the state of Texas, and then you ship it to Arizona, and the manufacturer, what you have inside your package, we don't know if they have a license here or they authorize to ship to Arizona to start. I mean,
okay. So manufacturing, when you define manufacturing, there is no limitation on repackaging / relabeling. If you receive a manufacturer's license in the state of Texas, you can actually manufacture from an API all the way to repackaging and relabeling. So there's no limitation in the scope of practice, that, because it sounds like you want to be specific to say we can only repackage / relabel. But as a manufacturer, we can actually manufacture all the way down to the API. That's not what we do, but we do have that ability. We have the rights to do that if we wish. But that's
absolutely. And we want you to have a safe business as well. And I want you to be able to ship to Arizona, but what I don't want to happen in future, you come before us of like other issues that we're not addressed now. So my concern not let you to ship to state of Arizona. I want to make sure we are all clear what type of business you're doing. You know what I mean? If we are clear what you're doing, so I believe nobody has an issue unless somebody can.
I think the real question is, does the Texas manufacturer permit allow them to ship other manufacturers' products into Arizona?
So this is the only question.
That's the outstanding question. Arizona's manufacturer permit would allow them to be a relabeler, similar to what Texas does. So that's the same here. The question is whether they would be able to ship other manufacturers' goods that they did not relabel into Arizona or distribute.
So can I make a motion like in condition verification with Texas, so don't need to come back to before the board if Texas allow them to ship other manufacturers?
Miss Galvin, would that be appropriate? Because we've got the two licenses and it sounds like they probably need both for us, but we need the answer about Texas.
That would be appropriate. That would be one option for you.
Thank you.
And honestly, if we're able to figure out this permit issue, if this was the only thing that was concerning, we may not need board consideration.
I believe this was one of the bigger parts of concerning to us. The other was about the change of ownership. If this board finds that it was in fact a change of ownership, then it would have been an untimely change of ownership based on no notification given to this board.
So let me just summarize this. This company moved from a father, like parents, to a son, right? And we see it as changing ownership. They don't see it as changing ownership.
Correct. Yeah, I'm not sure what you would call it, but
Yeah.
one company basically let their permit expire, and the other
Took
company
over the business,
There you go.
basically. Yeah. So it's a changing ownership.
And I guess their argument was that in their home state, it wasn't a change of ownership, and so it wasn't a change of ownership here as well. I'm not sure if this board's going to find the same. I guess that's up to you all.
And also
base our
there was
change
no
of
bill of
ownership off of what other states do. We have our own definition of a change of ownership.
So our definition is clearly is changing ownership, right? Our definition. So does it
Yeah.
meet, okay, meet that definition of changing ownership?
It sounds like the father was the 100% owner of the previous company,
Yeah.
and the son is the 100% owner of the
And our
new
standard with
company.
this, I believe, $250 for not notifying. Okay, so
And they also failed to disclose discipline that they had received
that's
on the new
250.
application.
Okay,
well, it's two different companies, so that was the only reason why. It wasn't that we were trying to.
Can we make action on this previous company ownership? Is this
It was the same designated representative, the same employees, the same facility.
same permit number?
They got a new permit when
Okay.
the son took over.
Yeah.
And also, when we went to the Arizona's board to look at the change of ownership documents, it required information that we didn't have, like the bill of sale, or it was like I want to say it was a bill of sale. You all wanted the bill of sale to notify you of the change of ownership. There was no bill of sale, so it wasn't not only that our home state didn't require a change of ownership. It was also that when I actually looked at Arizona's change of ownership process, we didn't have all of the documentation to to notify you of a change of ownership because there was no bill of sale. So
A bill of sale is not a requirement to notify the board of an ownership change.
well, it may have been something else. I'll look exactly because it's been months now, but whatever it was a contract. It was some document I needed to present to Arizona that we did not have because we didn't actually do a change of ownership. But I do understand what you're saying about you all view it as being a change of ownership, but if we didn't have the required information to submit it, if it was just a matter of just filling out a form and said this changed to this, it would have been completed. But it was more information you all were asking for when I looked at it that we didn't have. So I was like, well, okay, Texas didn't require it. So, and we don't have this information, so we couldn't identify this as a change of ownership anyway. But
Yeah.
I understand you all saying it's a change of ownership. I can understand that.
Yeah, it's taken, I believe, yeah, I believe like obviously it's the same building, same employees and everything. So close down permit, open a new permit. It is changing ownership from our definition.
Okay.
I mean, we can go back and forth, like 4 hours, but in our state is the change of ownership. And I don't think this like the topic can take like half an hour here.
Yeah,
but I believe like they're applying for manufacturer license, right? And they have wholesaler license already. So
No, they're applying for both.
they're applying for both at the same time.
Correct. And again, if their home state, they have to hold an equal or a better permit in their home state as to what they'd be applying for here. And that's the wholesaler permit confusion that's going on
Okay.
here.
So if applying to both, so there's no issue, right? So they can meet the requirements regardless what the state of Texas says.
Without more information, I would say that we couldn't I wouldn't feel comfortable making that decision today.
I agree. I
up to
agree.
you all.
Especially not the wholesaler permit. You may be able to decide they have a manufacturer permit in their home state, so they are eligible for a manufacturer permit in Arizona. But that manufacturer permit would not allow them to ship other manufacturers' products into Arizona. So that's the issue with issuing a manufacturer permit. If that's their business model, that's what they're doing, then we're basically giving them a permit to do that. But we don't have the same abilities that Texas offers.
So can we make a motion, because like, I mean, there is a violation of failing to disclose. This is, that is very standard, like, that's easy to decide. We still need clarification of what state of Texas allowed them to do with their manufacturer license, right? And I don't know if we approve upon verification from Texas. Is that
So
possible?
the application is in substantive review right now. We could issue them a written notice, a request for information. They'll have 90 business days to provide that information to us. If they don't, or they're unable to provide that, then the application would be incomplete and it would close after those 90 days.
But it sounds like we have met the requirements for a manufacturer's license, so that should at least be issued, and then it should be the wholesaler's license that should be held up for more information, not because we meet the requirements for the manufacturer's license because we have a manufacturer's license in our home state. That's what we're applying for. So at least that one should be issued, and then we actually don't purchase products from other manufacturers anyway. So I mean, why, I guess, why wouldn't the manufacturer's one be issued today? I guess that's my question.
So,
Hannah, do you need more information from Texas regardless on both?
I don't know if we need any further information about the manufacturer.
we can approve manufacturer upon paying $250 time two, because there is $250 for not reporting ownership for the manufacturer, and another $250 for a fail to disclose, and approve the manufacturer license upon paying this fine. And this is, can we do like one motion or two different motions?
Let's take them separate. So that would be item 15A for the manufacturer's license,
Okay,
right?
so this is my motion for manufacturer license. Approve manufacturer upon paying total of $500, $250 for each violation, changing ownership, and not fail to disclose the discipline.
Do I have a second?
Second. I didn't think it was working again.
Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Let's go back to the wholesale permit then, Tariq.
My voice much better here, right? Okay. So I move. I don't know if we need to table for more clarification. It is fair to say I'm bringing it back to us because we need clarification, right? Still from the state. So I move to table this for next board meeting after we. Yeah.
Mr. Al-Nasif, I think the only piece is if we get a letter from
Would be fine.
Texas, I think we meet requirements to issue it.
Okay.
So I don't think it needs to come back
Okay.
before the board.
So I move to approve the application after clarification, right, from the state of Texas about the scope of practice.
Correct.
And we allow to approve it if no problem. Otherwise, we bring it back to the state board.
Correct. I think the only thing Mr. Brumfield needs to know is we're also under time constraints as well. So the sooner you get that information back to us, the sooner we can issue it.
Yes, sir. I'll get it this week.
Okay, so that's my motion.
Second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. I think next I want to go to, thank you, Mr. Brumfield, for being present.
Thank you all for your time. I appreciate it.
I think we're going to go to the executive director performance review. Because we need to get it done, which is tab 24. And Ms. Galvin, do we need a motion to go into executive session for that item?
You do.
I move we go into executive session for tab 24.
Second.
I have a motion and a second. All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. For the members of the audience, we're going to go into executive session to discuss Dr. Gandhi's performance review, and then we'll go to lunch after that. So we won't conduct any other business other than I think we have to go back into open session to recess for lunch. Is that correct, Ms. Galvin?
That is correct. And to take any action pursuant to that review.
Okay. We'll come back from lunch at 1 o'clock, but we won't conduct any other business other than that before 1 p.m. Just for people in the audience. And we will see you at 1 o'clock. Welcome back, everybody. I can't see Cam if he's in the room, but Dr. Gandhi, do you want to do a quick roll call?
Certainly, Madam Chair. Mr. Thorwald,
Here.
Ms. Nair, Ms. Davis,
Present.
Ms. Walmsley,
Present virtually.
Ms. Mark,
Here.
Mr. Hogan,
Here.
Mr. Al-Asif,
Here.
and Mr. Anderson, not present, and Mr. Braswell, not present. 2 absent, Madam Chair.
Thank you. And just since I joined the meeting late, I know we didn't do my conflicts, but just for the record, I want to note that mine have been submitted in writing before the meeting. All right, let's finish up item number 24, which is the executive director's evaluation and compensation. Ms. Galvin, if you could direct me on an appropriate motion here.
I did not attend this executive session, but I'm assuming a discussion took place with respect to Dr. Gandhi's evaluation and
And
any
his compensation, yes.
and a salary adjustment. So the appropriate motion would be to proceed as discussed in executive session.
So I move to proceed as discussed in the executive session.
Do I have a second?
I'll second.
A motion and a second. Any discussion? All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. I will review the Dr. Gandhi's review with him and his compensation separately after the meeting. All right, Dr. Gandhi, remind me, we have requests for 15E and what other item to take because of flights?
15D as well after 15E.
Okay, 15E, then go back to D.
Yes. And while they're walking, Madam Chair, just a reminder, guys, if you want CE, please sign in for this afternoon session. And for those that didn't sign in this morning, can attest that they did attend the entire morning session. Please let us know.
All right.
Lori, Ms.
Thank
Walmsley.
you. No worries. Give me 1 second to get the book going again here. Item 15E is OPS International Incorporated doing business as Olympia Pharmaceuticals. And I see we've got Shirag available. So Shirag, if you want to give us a brief summary, but let's maybe do introductions first, starting with you, Chirag.
Sure. I'm Compliance Officer Chirag Patel.
Max Everett, the Director of Quality.
Good afternoon, board members. My name is David Flynn. I'm the Senior Director of Legal and Regulatory Affairs for Olympia Pharmaceuticals.
Hi, good afternoon. I'm Tracy Collier. I'm Director of Regulatory Affairs.
Okay. Olympia Pharmaceuticals has applied for a non-resident 503B outsourcing manufacturer permit and has disclosed a discipline by the California Board of Pharmacy for this location. In May of 2024, Olympia Pharmaceuticals reached into a settlement with the California State Board of Pharmacy for not meeting California's unique sterile compounding requirements. Olympia Pharmaceuticals was previously permitted as a non-resident sterile compounding pharmacy in California. When the California board implemented a new non-resident outsourcing facility permit, they allowed Olympia Pharmaceuticals to cancel its non-resident sterile compounding permit to pave the way to obtain licensure as a California outsourcing facility. Prior to doing so, the California board imposed a reprimand on the Olympia Pharmaceuticals California permit. No other discipline was imposed. Currently, Olympia Pharmaceuticals is not licensed in California, as it has yet to apply for a permit as a non-resident outsourcing facility in California. Olympia Pharmaceuticals have had 2 FDA inspections, one in 2022 and one in 2024, in the last 5 years, which resulted in FDA issuing a Form 483 inspectional observations being issued for each inspection. Responses to the inspection observations have been provided in the board packet. Neither inspection resulted in a warning letter. Olympia Pharmaceuticals has also undergone 2 recent State Board of Pharmacy inspections by Kansas in November of 2024 and Florida October of 2023. Both inspections were deemed satisfactory, and the reports are also included in the board packet. There was a complete change of ownership which occurred on December 17th, 2024. The FDA observations and California reprimand occurred under the previous ownership. No owners from the previous ownership is currently present at Olympia Pharmaceuticals. Olympia Pharmaceuticals has had no disciplines, no restrictions or probations on their permit in their home state of Florida. This application is in front of the board for consideration due to discipline reported in the state of California. Thank you.
Thank you, Mr. Patel. Would somebody from Olympia like to make any brief statements before we proceed with questions?
Thank you, Madam Chair. We'll go ahead and entertain any questions that you may have at this time.
Thank you, Mr. Flynn. Board members?
So here we are, just they are in front of us just because of the state of California discipline, which is just to unique requirements specifically to state of Arizona, right?
You got
California.
that.
Yeah. Okay. I mean, like from my perspective, I don't see a concern at all. And then unless somebody has other ideas.
I agree. I agree with you, Tariq. I don't have any concerns. This was under prior ownership. They've had 2 recent satisfactory inspections, so I don't have any concerns.
So I move to approve the permit application in state of Arizona.
Second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Thank you all for being here. Safe travels.
Thank you, Madam Chair, and thank you, board members. We appreciate your time today.
All right, we'll go back to 15D Pro RX. Ms. Chang, if you could introduce yourself and then the others follow her, please.
Will do. Good afternoon, board members. Nancy Cheng, Compliance Officer from the Arizona Board of Pharmacy.
Hi, Amanda Harris. I am the manager of regulatory compliance. And good afternoon. Thanks for having us.
Thank you for moving us up for our flights. I'm Greg Geiser. I'm Vice President of Clinical Operations and the head pharmacist at ProRx.
Terrific. Ms. Chang, if you could give us a brief summary.
Yes. U.S. Pharmacy Holding doing business as ProRx LLC is a non-resident 503B outsourcing facility in Pennsylvania. ProRx LLC had a change of ownership on November 1st, 2024, but it didn't submit the change of ownership application to the Arizona Board of Pharmacy within 10 days per statute. Additionally, ProRx LLC didn't disclose any disciplinary action issued by the FDA on 12/20/2024 to the prior owner until February 10, 2025, and stated that they had make corrective actions and policy changes in addressing the FDA concerns. However, the new owner didn't notify the Arizona board that on March 4th of 2025, the FDA issued an amended FDA warning letter to the new owner. The FDA acknowledged receipt of the facility's responses under the former owner to cease sterile drug production as of August 7, 2024, and on November 11, 2024, the new owners intend to resume sterile drug production. In both the FDA warning letter and the amended warning letter, the FDA stated that it appears the facility produced drugs that violates the FDCA. The informations are included in your package for review. The statutes and also the summary of the events are also listed for your review.
Thank you, Ms. Chang. Would either of you wish to make a brief statement before we proceed with questions?
Yes, hi. So the previous owners, when we had the first inspection, I've been an IV pharmacist since 1986. Couldn't believe what happened in there, not using gloves in the clean room and all that. So that's really horrible. So the new company bought them November 1st. They brought me in November 4th, as well as an outside FDA consulting team to basically clean up the operation, do the things. Their original response to the warning letter was 8 pages. Our response was over 300 pages to it. In March, so when they received our response to the warning letter, our updated response, which came to us right before Christmas, they gave us a little extension to get through that. The only question they asked back was, is Professor Gupta still involved in the company? And we said no. They said, okay. Then we received another warning letter. And if you look at the warning letter, what it says is, it's because the warning letter, when they issued it in December to us, was to the old owner who is no longer the owner. So they sent another letter saying this is now corrected to the current owner, but there's no changes or no additional. It wasn't like we had another inspection. So I've been answering this question a lot, as you could imagine. It was basically just amended to say we're addressing the letter to who it should have been addressed to in December.
Thank you. Board members, questions or discussion?
If you want to make another statement, go ahead.
Oh, yeah. I was going to say, as far as the delinquency and reporting the change of ownership, once it did occur, I sent an email. So I was left out of the change of ownership equation and actually found out on November 1st due to kind of the rush of the previous owners not understanding the gravity of the FDA, right? And so it occurred a little bit quickly. And so I apologize for that delay. That was on me. And then once I did get a response for the warning letter that our new ownership was submitting, that's when I did share it with the Arizona Board of Pharmacy. And if anyone needs a copy of the most recent warning letter, I have a cover page detailing that it's just addressed to the new ownership. Yes.
Can you go over some of the changes that were made?
Everything soup to nuts. They weren't following even USP 797. The previous owners were 2 college professors that thought they understood what it was, and it was primarily set up as an analytical lab. So I personally been through, I owned a 503B that I sold in 19. I personally been through 3 FDA inspections myself. So basically we've changed everything: SOPs, training, recertifications, smoke studies, environmental monitoring, continuous monitoring of the refrigerators. There's probably 40 different items that we track through our systems. All the staff is completely new. I rehired everybody. Most of our technicians have not only gone through our extensive training program, but most of them were sterile technicians from CHOP, Children's Hospital, from them. The pharmacists also came from home infusion backgrounds. I was also the regional manager for Quorum Healthcare when I was in home infusion. So basically, there's nothing, the equipment is not the same, the hoods aren't the same. You name it, we've changed it totally differently for it. I'm very confident, and I'm actually have been begging for an inspection, but the difficulty in Pennsylvania is that we're licensed as a manufacturer, not as a pharmacy, so they don't do inspections. So we're currently talking with, pursuing actively, it's funny, David Flynn's going to help us with that, pursuing getting a Florida inspection, because that's where my pharmacy was in Florida, a pharmacy inspection. There's also, Florida has some state outside consultants where they pay them to do inspections. And if any of you'd like to come inspect the facility, we'll gladly pay all the expenses. Because as you know, the FDA is under no obligation to issue a retraction or a correction to your letter. I'm still waiting for mine from 2017. So there isn't anything that you can ask me, anything you'd like to ask me. We've done everything. They've spent a tremendous amount of money, and it's not the same place. They basically, I had retired in 19 when I sold, and they basically got me off the couch from watching Wheel of Fortune to come back to doing this. So I've been at it, like I said, the joke is I was almost 40 years in the clean room, and they finally let me out. So.
So you'd indicated that you'd submitted the amended 483 to Arizona when you got it in March, but from the narrative that Ms. Chang said, it sounded like maybe that didn't happen.
I submitted our response to the warning letter in February, I believe. Yeah.
That's correct.
Yes.
But not the amended warning letter you received in March.
The amended warning letter was the one addressed to Mark, the new owner, and no, I did not submit that because again, the only thing different was the first page stating that it was to Mark, and not to Pardeep.
And what is status on other states? So all good standing at this time?
Yeah, right now we're in great standing with all other states. Our home state of Pennsylvania, I've communicated with them our status, and I've asked them on several occasions if they can come out and do an inspection, and they still won't. I have a letter from them stating that they do not perform the inspection, but we are still in good standing with them.
And you've had positive inspections since you've had this big turnaround?
No, I haven't gotten an official inspection, but we've had outside consultants, we've had gap analysis. And what I'm trying actively to do is to get somebody to come inspect us. Nobody yet, but we're trying.
Have you scheduled with NABP, or are you making any?
We're going to do through Gates, yes. We're going to do NAPB too, but they're also way far behind, but that's another one we're working on also.
Do you have Gates scheduled?
No, but we've sent an application to them, and we're in the process of working with the consultant.
We do have a contract, so.
May I add some comments? So on it looks like there were a lot of responses from the old owner and new owner to the FDA, and the FDA acknowledged receiving of their responses. And the other aspect is that the old owner at one point stated they will cease these sterile drug production in August. And as the new owner comes in November, they requested to resume sterile compounding. So I think there is the time frame based on what the new owner responses to the FDA. Afterward, the FDA still went and sent the amended FDA letter of concern, warning letter. So just to clarify the timeline for how that all comes about.
Thank you, Ms. Chang. Board members, any additional questions?
So just to make sure, you already stated so the previous owner no longer at anyhow, right? Any capacity?
No, if he,
Neither, yeah.
I call the police if he walks by the building.
Okay, I mean, I make sure you're gonna call the police, okay?
No, absolutely. Can you imagine not wearing your sterile gloves in a clean room in front of an FDA investigator? I mean,
Sounds like the wheel of misfortune.
yes, absolutely, yes.
I don't know, Dr. Davis, do you have concern here? Because you are the
No,
expert in
I don't
that?
really have any concerns. It sounds like that they've done a full, analysis of the business practices and, are just waiting for a formal inspection. I think the only thing is maybe a failure to notify within 10 days. So, I'd make a motion for a $250 civil penalty for failure to notify of ownership change under the 10-day period and to approve the non-resident manufacturer permit.
Second.
A motion and a second. Any discussion?
Madam Chair, just a quick question. Nancy, did we get consults reports or anything like that?
From the FDA,
No, from the permit applicants.
the applicant did send the,
You have those consultant reports that you can share?
the consultant report. No, actually, I did not.
Yeah, we sent you the whole, they helped us write the response to the warning letter.
The response, but the individual assessment from the.
Well, they do ongoing. They're constantly in the facility. So we're having a gap analysis. It's not a formal gap analysis, but it's the changes. I can send you our action plan from everything we changed. Is probably about 2,000 different items that show. I managed I came from quorum, so everything was by reports,
Yeah.
pivot tables and all that. So everything's that, and I can send you the list of everything we track. I'll be happy to share it all with you. I'm quite proud of it, actually.
That may help for our records.
Yeah, it'd be more comforting to
Sure.
actually have.
It shows in writing
Changes.
the time, the changes, what we, sure, my absolute
Yeah.
pleasure.
Do we keep the same motion, right?
Yep, I have a motion and a second. Any further discussion?
Do we need to amend the motion that they'll provide this report with the $250 civil penalty? Or okay.
Yeah, it's called my action plan. You'll see it.
Okay, all those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Thank you so much for being present. I think that takes us to 13B. Is that correct, Dr. Grandi?
That is correct, Madam Chair.
Okay, Virtue RX LLC. Dr. Gandhi, I think you probably can address this one, but we have an order that's in the book, right?
I do, Madam Chair, and there were two issues that were identified in the review of this matter. And it's notifying us on the application of previous discipline and also shipping into Arizona without having a valid permit are the two issues. I've had discussion with the individuals, the applicant themselves, and they are in agreement to the order that's in your board book of $2,850 to address the two matters that were of concern.
So the request is for us to ratify that order and upon payment, issue the permit.
Yes.
Okay, I'll make a motion to accept the agreement and upon payment issue the permit. I was trying to say, it was the application or permit.
Second.
Yeah, and it's an order, it's not a agreement, so.
All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Thank you.
Good job, Max.
Does that take us to 15B? Am I tracking here?
15B has been tabled, Madam Chair.
Okay.
We're going to 15C.
Okay, 15C. Did we already take care of 13D, Dr. Gundy?
Yes, we did, Madam Chair.
Okay. All right, 15C is Anavex Pharma. I see Ms. Cheng, if you could please introduce yourself and if anybody else is present from Anavex.
Yes, this is Nancy Chang, Compliance Officer from the Arizona Board of Pharmacy.
And this is Dio Akimbi, CEO of Anavex. I also have with me Peter Hong, our Director of Pharmacy and Manufacturing Operations, and also Jalissa Yedra, our Manager of Quality Assurance, and Karthika Devaraj, our Quality Control Manager.
Thank you. Ms. Cheng, would you like to give us a brief summary?
Will do. Anavex Pharmacy Inc., a 503B outsourcing facility in Lawton, Virginia, applied for a non-resident manufacturer permit with the Arizona Board of Pharmacy on December 20th, 2024. I would like to clarify that although Anavex Pharmacy didn't disclose any disciplinary actions on the Arizona Board of Pharmacy application, they did include the FDA 483 warning letter with the application package. During the substantial review, we also found the FDA 483 warning letter, which outlined multiple violations from the FDA inspection of Anavex Pharmacy conducted on August 26 to September 6 of 2024. The FDA finding include inadequate validation of the aseptic process, failure to explain the microbial growth found in the media field performed on January 4, 2024 to January 5, 2024, failure to investigate the HEPA leak test failure, and other observation as outlined in the board review package. The Anavex Pharmacy submitted several corrective action plans to the FDA between September 2024 to December 2024. On March 5th of 2025, the FDA issues a warning letter to Anavex Pharmacy stating that it appears the facility produced drugs that violate the FDCA. The citations are listed in the substantive review report. And that's it.
Thank you, Ms. Cheng. Mr. Akimbi, would you or anyone else like to make a brief statement before we proceed with questions?
Yes, and Anavex, just historical context, basically came to market very early in 2024, and we started with mostly non-sterile products. We were essentially in our testing phase, validating our sterile operations. When a couple of months later, we had a visit from the FDA. So a lot of those early issues that we had already mostly been remediated by the time we actually had the FDA inspection. But we've also been working on a very, very robust corrective action plan, as well as a preventative action plan, which, again, as noted, we have made multiple submissions to the FDA. Unfortunately, there were a couple of submissions that we gave the FDA in January and February of 2025 that were actually ignored, or at least not addressed in the March warning letter, which had largely fixed a lot of the issues that were actually cited in that warning letter. However, we have continued to stay robustly engaged. We've also engaged outside help, with consultants to perform gap analysis and also to help remediation of all the issues that were found. I will note that a lot of the issues that were found were actually mostly one-time fixes. We neglected to report fully items that were are made because of some confusion around what needed to be reported to the FDA. And so a lot of our testing samples that we made for the lab essentially were reported in one particular reporting. So that was outlined, and we corrected our SOPs as well as our operating procedures to make sure that that doesn't happen again. So essentially, that's kind of where we are. We feel very, very confident that we've addressed a lot of those issues. We haven't had any failure of any batches, since inception that have actually made it to the commercial realm. So we're very excited about that, and hopefully we'll be able to bring some of our, our good products to bear on the good people of Arizona.
Thank you. Board members, questions?
I don't have a question, but it looks to me that most of my concerns have been addressed. Looks like their corrective actions are appropriate, so I would make a motion to approve the application.
Second.
A motion and a second. Any discussion? All those in favor? Aye. Any opposed? Hearing none, motion carries. Thank you all for being present.
Thank you, board. Appreciate you.
Thank you. Next, we'll do items 18A and 20A since they are related. Jason McEwen-Klontz. Good afternoon. If you could please introduce yourself, starting with Ms. Foltz.
Jenica Brown, Executive Assistant to the
Sorry,
Deputy Director.
Jenica. I couldn't see you that well. Sorry.
Good afternoon, Chair, members of the board. Flynn Carey, Counsel for Licensee.
Jason Klontz, applicant.
Welcome. Jenica, if you could give us a brief summary of the application.
Certainly.
Well, Laura, I don't know which order we want to go, but go ahead and give us a summary regardless.
Thank you. Jason Klontz was issued an Arizona pharmacist license by full exam on July 30th, 2012. His license has been suspended since February 14th, 2022. On August 27th, 2021, Mr. Klontz notified the board that he had been charged with surreptitious recording and voyeurism. According to the arrest warrant, he was arrested on August 16th, 2021 on 2 felony counts of voyeurism and 2 felony counts of surreptitious photographing, videotaping, filming, or digitally recording. During the investigation of his self-reported charges, staff came across separate charges from 2003 for indecent exposure that he did not previously report to the board. Further information regarding the charges are contained in the board's files for review. On January 20th, 2022, Mr. Klontz entered into an interim consent agreement for voluntary suspension of license pending the investigation of this matter. The agreement was considered by the board and approved during the February 2022 board meeting. The agreement was executed on February 14th, 2022. On February 10th, 2023, judgment was entered against Mr. Klontz, and the determination of guilt was based upon his plea of guilty to 2 counts of surreptitious photographing, videotaping, filming, or digitally recording, both Class 5 felonies. The factual basis in support of the guilty plea relates to his surreptitious placement of video-audio recording equipment in a bathroom of a private residence to which he had access and knowledge that the residence was going to be occupied by 3 young women in the coming days. Staff reached out to Mr. Klontz's counsel in April 2024 to determine how Mr. Klontz would like to proceed. Staff received a response indicating that Mr. Klontz anticipated that his probation would likely end in a few months and asked that his license remain on an interim suspended status until the conclusion of his court issues. Staff followed up with Mr. Klontz's counsel at the end of October 2024 and requested an update in this matter. Staff received a response indicating that Mr. Klontz's probation officer requested early release of his probation in September 2024 and indicated that they expected to have more information shortly. On January 15th, 2025, Mr. Klontz's counsel submitted a supplement regarding his criminal matter, which is included in the board's files for review and consideration. Staff further advised Mr. Klontz counsel that if he intended to retain his license, he would need to submit an application for renewal. His renewal application was received on March 17th, 2025. Upon further discussion with Mr. Klon's counsel, an interim order for an evaluation was issued in this matter on March 19th, 2025. Mr. Klontz complied with the order, and the evaluation results are included in the board's files for review and consideration. This matter is before the board for discussion, consideration, and possible action regarding the facts of this case, the suspension of Mr. Klontz's license, the results of the evaluation, his underlying conduct, and his renewal application.
Thank you, Ms. Brown. Mr. Klontz, would you or your counsel like to make brief comments before we proceed with questions?
Yes, Chair, members of the board, I have a few thoughts in relation to this case. I would also ask that once I am done, if it would be, I would invite the board to consider doing an executive session. I'm assuming for healthcare information, but also assuming you're going to add legal advice to this one. But at least for the health advice, we do have some information related to the evaluation that would fall under confidential information for the board. Overall, this is a case in which the licensee reported his arrest, agreed to an interim suspension to not practice while his case was being adjudicated, and complied with the board requirements, including a very comprehensive evaluation by a qualified expert approved by the board. I am prefacing my comments in that you're not going to hear anything today from either me or Mr. Klontz making an excuse for the conduct, but I think there is some context and additional information in the healthcare records that are very critical to how this could have occurred. I think what's important here and is first, the genesis of this offending behavior did arise from some very serious childhood trauma, which has been documented heavily, that was perpetrated against him. And in executive session, we can provide greater detail on that. I think suffice to say the conduct of others perpetrated against him offers some greater insight in which why he exercised such poor decision-making here. I'm going to tell you a significant legal argument here that I know your counsel has heard a number of times, but it's, I think, really critical. This is, again, I don't want to step away from the seriousness of the situation, but I think it is critical that there may not be a sufficient nexus between the practice of pharmacy and the offense. It unquestionably did not occur while he was providing any sort of pharmacy services, patient care, or related to his employment. And the law, nothing that I drafted, nothing that was created by your board either, just the law in general in Arizona, is that there has to be a nexus between the regulated activity, here the practice of pharmacy, and the criminal conduct. This is not a case involving, for instance, drug use or drug diversion, where that nexus would be very clear. This is a case involving out-of-license conduct that didn't occur in a work setting. Your statutes require a substantial relationship between the practice of pharmacy and out-of-work conduct. That's in your statute. And so I would suggest that the mere fact of a felony conviction is insufficient to discipline. There still needs to be a nexus. And this is because boards in Arizona are not general law enforcement agencies. You're a law enforcement agency for pharmacy-related issues, but you're not a general law enforcement agency like either our courts, the prosecutor's office, or the police departments. There is a case on point here. It's called Winters, and I cite to Winters a lot, and it's involving the Board of Education. And what it states is essentially your crimes have to have a nexus to the license. In that case, the teacher submitted that his off-campus conduct for which he was being disciplined must bear a reasonable relationship to his fitness as a teacher. The court said, we agree. Off-campus acts must relate to his or her fitness as a teacher and must have an adverse effect on or within the school community. This nexus requirement has been adopted by the majority of jurisdictions that have considered the issue. In Winters, there was a significant number of cases that had involving that teacher that had a clear nexus to the practice. He had a disorderly conduct arrest. He discharged a firearm into his neighbor's air conditioning unit. He got into fisticuffs with one of his neighbors. He threatened one of his former students, and he told the neighbor children that they better sleep with one eye open. Obviously, conduct very connected to the practice of teaching. He, of course, lost his license because there was the proper, which we now call the Winters nexus. In addition, we're asking that you consider the significant rehabilitation that led to his probation officer recommending early termination, something that does not always happen. In addition to the evaluation that we can talk about in executive session, his probation evaluation for his pretrial services report, or his sentencing report indicated he was a low risk to reoffend. And that's criminogenic, meaning it's a criminal-based evaluation as part of his sentencing process. The evaluator specifically noted in his report in the board-ordered evaluation, there is no reason to believe that Mr. Klont's behavior in this incident would render him unable to practice appropriately, safely, and competently as a pharmacist. The behavior occurred in the context of his personal life and was influenced by a complex family history that would have little impact on his professional practice. Again, that is from the board-approved provider. The evaluator also provided on pages 19 through 20 of his report some recommendations that I think can readily be converted into a consent agreement. They are significant. They are not, minor items. These are things that will follow Mr. Klont significantly during his pharmacy practice, including notifications to his employers. This is a unique situation, and this is not the case you normally get in front of you, and I appreciate that. What I have attempted to do is guide the board through this evaluation and through the other materials in some ways in which this license can be salvaged, but still put some guardrails in place for public protection.
Thank you very much. Board members, questions? Or shall we entertain a motion to go to executive session to talk about the medical evaluation and potentially legal advice?
I'll make a motion for protected health information executive session with the potential for legal advice.
Second.
A motion and a second. Any discussion? All those in favor? Aye. Any opposed? Motion carries. We'll go ahead and get set up for that executive session. All right, welcome back, everybody. After executive session, do we have any further questions for Mr. Klontz or discussion?
So, oh no, not everyone here yet. Just to make sure everyone.
Yep, got you, Tariq.
Okay, I'm ready now. And my mic works better than this morning. So did the court ask you to register and you've done it already? Did they give you like option to be off the list in certain time or?
They did inform me that at the end of probation, it was supposed to end, but that hasn't happened. I'm going to work with an attorney and find out exactly what that status and situation is.
And part of the court order, are you required to inform your employer and all of this, or they don't discuss this with you? Okay, just to make sure. So you registered as you asked to. Okay. So there is, I believe, standard for probation, right, Dr. Candy, including not being PIC or PIC or. So what's the
PIC,
standard?
preceptor, et cetera, others.
Okay, so standard, we don't need to discuss this because this comes automatically with the probation.
As long as you say probation with standard terms.
Okay.
That would be included in there, yes.
Okay. So we have, I asked you this question inside, but this is not like confidential. So question. So do you have opportunity, like, do you have like a job opportunity now?
Yes, I do.
And you mentioned it's like community work opportunity and online, right?
I know there are online options available, but there is also a community pharmacy, an independent one who would like some relief work.
Okay. So I mean, unless anybody has anything to discuss, I mean, I can make a motion here. So I move to remove or lift the suspension and go with the 3 years probation, and that's the maximum we can do, right, Mr. Calvin? 3 years. Yeah.
That is not the maximum. You're not aware of any maximum. The
Okay.
evaluator suggested, 2 to 3 years.
Oh, okay, that's suggestion. Okay, so there's no max from our part, so we can go. So I will go with the 3 years probation, just like to match the recommendation, and I suggest in my motion I include 20 hours a week maximum to work, and if you want to increase the hours of working, you need to come before the board to ask, not to lift probation, to increase the hours. You know what I mean? And I believe we already discussed that. You already been up to date with the pharmacy. I don't have a concern about this.
I see no reason to limit the hours myself
At
all.
It just like, this like my idea, just because not only for public safety or for any of this, also for his, and he mentioned, you know what I mean, like, are you okay with, do you think that would benefit you? It's just not like for public safety, it's for your benefits and for, you know what I mean, just to go.
I would be more comfortable self-limiting myself and working up as I would see fit. I agree. I don't know that there's necessarily a need to limit at 20 because the situation may require, hey, we're going to need you 30 hours this week.
Okay.
So,
and also you need to continue evaluation within your probation and report to this to state board every 6 months, like doctor's notes and or evaluation. And yeah, I modified. There's no limitation of hours. So this is my motion.
Second.
If I may seek clarification, are you suggesting or moving that the probation and the terms mirror what the evaluator had recommended in his evaluation?
For 3, yeah.
Okay, and with the additional standard terms that the board has, that would also include periodic reporting from the named professionals. Is that
Correct. And my motion included like every 6 months we need to get a report. And of course, like that, the standard notify his employer, right? About
It's worth mentioning.
yes, yeah. So yeah, I include also notifying employer.
And do we also need to, upon execution of the consent agreement, all that good stuff, also approve his renewal application? Because I think that is also on the agenda.
Yeah. We need also acknowledgement from his employer that they're aware of the probation and the type of probation, you know what I mean? So when you notify your employer, you need to tell them it is your responsibility, not them, that they need to send an email to board staff here about they're aware of the probation and the conditions. So if they fail to notify us, it's not on them, it's on you.
My second includes all
I
of it.
think, Madam Chair, if I may add one more suggestion.
Please.
Failure to go to therapy or the assistance that he's getting, that he automatically surrenders his permit.
Yeah, I modify my motion to include this. Any violation of evaluation, right? Or like continuous treatment.
He's
that-
gotta continue treatment until the evaluator feels that he no longer
Yeah.
needs it, but he can't make the determination himself
Correct.
and terminate that relationship.
Okay.
And I modify my second.
Yeah, that's included.
I have a motion and a second. Any discussion? Dr. Gandhi, if you want to do roll call, please.
I'm sorry. Oh, Frank, I'm sorry.
Certainly, Madam Chair. Mr. Braswell is absent. Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Park,
Aye.
Mr. Hogan,
Aye.
Mr. Al Nassif.
Aye.
Mr. Anderson's absent. So 2 absents. Ayes have it, Madam Chair.
Thank you, Dr. Gandhi. Appreciate it. Welcome back to practice, Mr. Klontz, and best of luck to you. I
Do
Go
you
ahead.
want the renewal application?
That was it.
Was that?
That was a part of it, yeah. I have a request for a bio break, so let's come back at 2:20. Welcome back, everybody. I think I see everybody is back at the table, so we can pick up at item 19A. Does that sound right, Dr. Gandhi?
That does sound right, Madam Chair.
Okay. Francis Edward Burns, pharmacy technician trainee applicant. Is Mr. Burns present? Dr. Gandhi, do we know if he's present online?
And Madam Chair, I don't see him online.
Okay. Do we want to go ahead and proceed, or do we need to speak with him?
Madam Chair, I think we proceed. We have timeframes we're held to on applications. So I think
Okay.
resolution.
Okay, sounds good. I can't tell who's at the table right now, so whoever is, if you could please give a brief summary, because the window's little and I can't tell by the.
Hannibal, licensing division manager. Mr. Francis Edward Burns applied for a pharmacy technician trainee registration. I'm sorry, can we pause? Okay.
Yeah, there's
Is somebody?
There is a weird echo on my end.
Okay.
Does it sound better now? Okay.
Much.
Yes. Francis Edward Burns applied for a pharmacy technician trainee registration on December 18th, 2024. During the initial review, we found that Mr. Burns had previously applied for a technician trainee license in 2020, and on that application, he disclosed a misdemeanor theft charge. Basically, he came into control of some stolen funds. They were directly deposited into his account by somebody else. And when he saw that he was in possession of those funds, instead of trying to find the correct owner or figure out what had happened, he cashed those funds and took them. So he was he pled guilty to count 1 of theft and was sentenced on a later date. He was sentenced to pay $1,650.22 to Bank of America, served 30 hours of community service, and served 2 years of probation. In 2019, he was granted early termination of his probation. Thank you.
I know you probably really can't answer this, but in my reading, it looked like he was part of a scheme. They were transferring money to each other. It wasn't just like, oh, this happened to come about. It was part of an overall scheme to do that with each other, working together.
That's what it seems like, but it doesn't, there was no documentation indicating that there was any connection between the other guy that was transferring the money to all kinds of different accounts and this person. So it wasn't really clear to me whether he just didn't know this person and his account was used for that other person's scheme, and then he didn't do the right thing when he saw he had the money, or he was involved in that scheme. It's not clear to me with the paperwork that he provided.
And didn't he work at the bank?
I believe so.
Can I ask what happened to his 2020 application for pharmacy technician trainee?
Yeah, that application timed out. He didn't provide the documentation that we requested related to his disclosure. So after the 90 days was up, the application was just closed. He never reapplied until this year or last year.
Did you request the court documents?
We did.
Did you get them?
What you have in your packet is everything that we got.
Yeah, I didn't see anything specific with regard to others. That's why I asked that.
Yeah, so that was more in the investigative notes of the detective. Can't say exactly what page that's on. But basically, there was another individual who was
taking money out of accounts and transferring them to other Bank of America accounts. And then somehow he was able to get his hands on that money. So money was transferred to Mr. Burns's account, and he woke up one morning, he had an extra $2,300 in his bank account, and then he quickly went to the bank and he withdrew that money.
I asked that question because I just didn't see any clarity in quite a few of these schemes around the country that where they steal money. They have somebody that is, for all intents and purposes, a mule or somebody they go through where they cash the money for them and then send it to them indirectly. That's why I was asking.
Yeah, that's a good question. Unfortunately, I would love to hear his explanation.
And I'm assuming he's aware that we are discussing his application today, and he's not joining us, right? Is he?
He was aware his application was tabled at the last board meeting because there was a birth. So he missed because he had a child. So he asked us to, skip over him. So we tabled it at his request and we rescheduled it, and he was notified and noticed.
Yeah. I mean, I would like to hear from him, but the fact that he failed to show up today to just give us more details, and I mean, the whole case is not really clear to me. I don't feel okay from my end to approve. And we have a time here. We need to make a decision regarding his application. I don't feel safe to approve his application at this time. It doesn't mean he cannot reapply again, but he needs to show up and discuss it with him. So, I mean, I move to deny his application.
And the basis for the denial would be what?
Is it of the type of a charge as not clear information that are provided by the applicant and court, right? We didn't have the details from court yet.
I'm not sure whether the documentation wasn't available.
Yeah.
It might have not been available, and he provided everything that the court did give him.
Yeah.
This wasn't my application. This is Jordan Jimmy's. He's the man behind the curtain of our board meeting right now. So unfortunately, he's not available.
Yeah. So yeah, I mean, for the type of the charge he went through.
He gave us quite a lot of documentation. It's just not clear in that documentation whether they were able to establish that he was involved in that scheme.
Correct.
But he did receive a conviction.
He pled guilty.
Yes, yes.
Yeah.
So based on
And
that.
that type of charge. This is my own opinion.
I'll second.
I don't know that I feel like denial is the right direction. I almost would feel better if we tabled it and subpoenaed him to appear, to at least give him the chance to hear his story and ask the questions. I think it's unfortunate that he's not here, but I don't know that I have all the information that I need to say that he shouldn't have a license either.
Yeah,
that's just my perspective.
We tabled it last time. I mean, upon his request, he requested to, and we did. And yet we just meeting now, and he is not here to discuss this with him. And also, to me, it shows like he's irresponsible for his own application, right? And then I understand he submit what he has, but I don't know if that's all what he have like to share with us.
I would be more for tabling it one more time.
Madam Chair, the only concern, if I may, is he applied back in December of 2024. Tabling it, his application may expire between now and our next board meeting because of the time frame issue. Us tabling it does not put a stop to the timeframes that we're held accountable to.
Would you maybe be interested in us requesting a statement from Mr. Burns on whether he was involved in that scheme?
But he got convicted, right? So I believe the court already did this, and then he's part of it. Otherwise, right? Am I wrong?
Only other proposal I can do before I answer that is maybe we can make an attempt to reach him before tomorrow.
Right.
And if he doesn't come tomorrow, then I think maybe he's struck out.
I would be much happier with doing that.
So
I do
I rescind my motion.
I'll rescind the second.
So table it till tomorrow.
So move to
Okay.
table. this for
Okay, so we'll come back to that tomorrow and you'll have staff reach out to him.
Can I ask you a quick question, please?
Yeah.
So deny his application, does he have to wait any period of time or could he immediately reapply if he wants to?
You could apply immediately and then we go through the same song and dance all over again. And it's also reportable to the national practitioner. Study was denied.
And if we deny him, then he has the opportunity to appeal that.
Yeah.
Okay, let's go to 19B. Triman Lee.
Present.
I'm going to recuse from this one based on my employment. So, Ms. Davis.
Sure. Welcome. Ms. Bolts, will you give us a summary?
Certainly. Triman Lee applied for pharmacist licensure by reciprocity on December 9th, 2024. He disclosed a 2006 criminal drug diversion charge and disciplinary action taken against his Florida pharmacist license. The circumstance which led to Mr. Lee's arrest is unknown, as the records retention period lapsed and all court documentation was destroyed in accordance with the Florida Rules of Judicial Administration. He was disciplined by the Florida board. And we also received a fingerprint clearance card denial letter for him, indicating that he was arrested and or fingerprinted for trafficking controlled substance opium on or about June 6, 2006. The settlement agreement issued by the Florida Board of Pharmacy indicates that Mr. Lee admitted to the factual allegation that from about August 2005 to January 2006, he dispensed hydrocodone of several strengths to one individual without a valid prescription. He invented fictitious patient names and used legitimate doctors as prescribers to dispense approximately 600 to 1,000 hydrocodone tablets to this person. He's before you today for consideration of his pharmacist application.
Thank you. Mr. Lee, would you like to make a statement before we proceed to questions?
Yeah, just want to say thank you for having me on. And I'm requesting Arizona licensure at the request of my current employer, which is Molina Healthcare. And what I do is I review prior authorizations, and my region includes Arizona, and it requires that I have a license. So I do not plan to practice in Arizona. I'm just getting the license so I can review with my team.
So, what's your position at this company?
They call me utilization management pharmacist. So I just review prior authorization cases for insurance coverage.
So
I don't dispense. I work from home remotely.
So his license, we require his fingerprint clearance, right? And that's get denied?
It was denied, but it looks like he did a good cause exemption and he was issued a card.
And all of this took place 20 years ago, is that correct?
Roughly, yeah.
Mr. Lee, was the arrest for trafficking controlled substance opium related to the hydrocodone diversion? Are those the same thing?
Yeah, it's the same.
I think considering the time that's gone by with nothing that we're aware of that's happened since then, I'll make a motion to approve the application.
Second.
Oops, sorry, that's me. I have a motion and a second. Any other discussion? All those in favor? Aye. Any opposed? Motion passes. Congratulations, Mr. Lee.
Thank you very much.
Thank you, Ms. Davis. We'll go to 19C, which is Harriet Reed. Hi, if people could introduce themselves, starting with Ms. Bolts.
Hannah Bolts, Licensing Division Manager.
Christina Castro, Licensing Administrator.
Harriet Reed.
And Jim Corrington with the PAPA program.
Welcome. Either Ms. Castro or Ms. Volts, you want to give us a brief summary?
Sure. Harriet Reed applied for an Arizona pharmacist license on February 14, 2025. Ms. Reed currently holds a pharmacist intern license issued on January 7, 2021. The intern license was suspended on October 25th, 2024 for a minimum of 90 days and then subject to a period of probation to include monitoring and rehabilitation. Ms. Reed appeared at the February 2025 board meeting and requested that her suspension of her intern license be lifted. Having considered testimony from Ms. Reed and verbal testimony from PAPA representatives, the board voted to offer Ms. Reed the first amended consent agreement and order. Upon the effective date of the first amended consent agreement, February 27, 2025, the suspension of Ms. Reed's license was lifted and Ms. Reed's intern license was immediately placed on probation for a minimum of 1 year and 6 months. She's here to apply for her pharmacist license.
Thank you. Ms. Reed, would you like to address the board?
Yes, thank you. Good afternoon. Thank you for your time. I am here to humbly request your favorable decision to approve my license to be a pharmacist.
Thank you, Ms. Reed. Mr. Corrington, are you supportive of this request of Ms. Reed, and what's your perspective on her progress?
Yes, absolutely. Once again, Jim Corrington, licensed clinical social worker and the weekly group facilitator that Harriet attends. So I see her every week for 1 hour, and she's been very compliant in the PAPA program in every way, and she's done a fantastic job so far. And Ryan Grease, who couldn't be here today for personal reasons, is also in full support, and she's compliant with everything that she needs to be, and we fully support her on her efforts that she's made. Worked very hard to go to pharmacy school and to become a pharmacist, and she's doing what she needs to do. Yes.
I'm sorry, just a quick verification. So we're talking about 19C, right? C as a cat. So because it says pharmacy technician license application.
That is a typo that we didn't
I just-
discover until recently. So,
Okay.
yeah.
So we can move to amend this, you know what I mean? So.
So
Sorry.
considering, I think that this seems to be in order. You've since passed, I assume, your NAFLEX and MPJE. I don't know if it would be standard, Ms. Galvin, to approve the pharmacist license and then immediately place it on probation to mirror the probation that was placed on the intern license?
I believe the intern license was placed on probation in February of this year. Is that correct?
Yes, that's correct.
Okay, and that was
then-
for, go ahead.
Yeah, and then you guys had asked if I had applied for the license, and the delay for that, I didn't have any money at that time to apply. So once I was able to go back to work, then I applied and I was able to. That's where we are now.
And the probation was for 12 months?
A year and a half.
Okay. All right. So, yes, if you grant her request, grant the pharmacist license, it would be placed on probation for the remaining period of time, subject to the same condition.
Yes, that's my motion.
Yeah, correct.
Second.
A motion and a second. Any discussion? Dr. Gandhi, roll call since this will require a new agreement.
Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Park,
Aye.
Mr. Hogan,
Aye.
Mr. Al Nassif.
Aye.
Mr. Anderson's absent. Mr. Braswell is absent. Ayes have it, Madam Chair, with 2 absence.
Thank you, Dr. Gandhi. Congratulations, Ms. Reed. Thank you for being present today. We'll go to item 20B. This is for Kurt William Adkins. Dr. Gandhi, do we have a signed consent agreement in the book now?
Madam
Bourbon.
President, this is
Bonder,
Jennifer
Sanders.
Brown, Executive
Yes.
Assistant to the Deputy Director. Mr. Adkins did contact staff and he indicated that he desired to surrender his license. There is a signed agreement in the board book for the board's consideration.
Thank you, Ms. Brown.
I'll make a motion to accept the surrender.
Second.
I have a motion and a second. Dr. Gandhi, roll call.
Thank you, Madam Chair. Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Spark,
Aye.
Mr. Hogan,
Aye.
Mr. Al-Nassif.
Aye.
Mr. Anderson, absent, and Mr. Presswell absent. Ayes have it with 2 absents, Madam Chair.
Thank you, Dr. Gandhi. That takes us to conferences, I believe. Let's go to item 21B, Tyler Hetherington and CVS number 4795. Welcome, everyone. If we could have people introduce themselves, starting with Mr. Jacobson.
Hello, Max Jacobson, Compliance Officer with the Board of Pharmacy.
My name's Tyler Hetherington, Pharmacist.
Thank you.
I apologize. Once again, Brian Convery. I'm here as a representative of CVS 4795.
Thank you. Mr. Jacobson, if you could give us a summary.
Thank you, Madam Chair. In this case, a complainant alleged the patient had gotten 50 micrograms of a medication. I'm sorry, she had been on 50 micrograms of a medication, and the pharmacy gave her a 75 microgram prescription. The permittee's regulatory department stated there was no DUR performed for this dispensation because it was on auto refill, and the fill of the medication was due based on timing of the previous fill. Basically what happened was this patient was on one strength of the medication, and then a new prescription had got called in, and that old prescription never got deactivated. And because it was on auto refill, when it was due for it to be filled, it was just automatically refilled. When I asked the pharmacist and indeed regulatory why this wasn't caught on DUR, basically the answer that kept coming back to me was there was no DUR performed because this was a refill and it was on auto refill.
Thank you, Mr. Jacobson. Mr. Hetherington or Mr. Convery, would either of you like to address the board before we jump into questions?
Thank you, Ms. Walmsley. I would love to. To address the concerns that came up, I saw at the committee meeting, what Mr. Jacobson was told by our regulatory department is incorrect. And I apologize to the board for that. I need to reiterate and make very clear that every prescription that is dispensed from any CVS, not just in Arizona, but nationwide, goes through the DUR process. So when the regulatory team told Mr. Jacobson that this prescription did not go through a DUR, that was wrong. This prescription did go through a DUR. An alert didn't fire for this one, but it went through the DUR process when the 50 microgram came up approximately 80 days prior. I'd be happy to explain the process of how that happened, but I want to make very clear it did go through the DUR process.
So it went through the DUR process, but did not alert the user.
So
right?
we've done enhancements on our DUR process. We are trying to reduce alert fatigue. So the patient, as Mr. Jacobs said, the patient was on 75. The 75 was filled, I believe, the last time in February 12th. The 50 came in about 2 weeks later. When the 50 was filled on, I believe, February 22nd, the DUR system at that point picked up the duplicate therapy. The pharmacist did put notes in the system, did talk to the patient, did call the doctor, I believe, and talk to the patient. What the pharmacist should have done at that point was deactivate the 75. The pharmacist did not. So the DUR alerted, the DUR did catch the duplicate therapy for when the 50 first started. So when the 75 came up in May, again, we're trying to reduce alert fatigue. Because the DUR alert had been credentialed, had been cleared, it didn't fire a second time for a duplicate therapy because the system is reading it as, oh, someone's already fixed it, someone has already done something. So we're again trying to reduce the alert fatigue. It didn't fire a second time.
But this was for a different strength.
The 75 was the original,
previous.
switched to 50, and then the ready fill, because the 75, the original 75 wasn't deactivated, when it came up for ready fill again, it automatically filled.
So the system isn't set up to catch the fact that a 50 milligram was filled and dispensed.
The system picked up the duplicate therapy for when the 50 first came in. But again, because someone cleared that DUR alert, it's not firing another alert again.
When you say someone cleared it, is it documented in the system?
It is.
Who-
There are notes. There are no, and I believe, Ms. Nair, I believe you were the one at the committee meeting who noticed that there were notes there. I believe the committee, you looked at it and you said, we weren't sure when those notes were put in. They were put in when the 50 was first filled. There's a note in the system that says, there's two notes, one on the 22nd, one on the 23rd of February. The 22nd says, we'll speak to patient. The 23rd says, spoke to patient's sister, duplicate therapy. It should have deactivated the 75 at that point.
Are they the same pharmacist who did the initial DUR review? And
I honestly don't know. I could look into it, or maybe Mr. Convery knows.
The pharmacist who did the DUR alert was not Mr. Hetherington.
the first one. So, I mean, yeah. So the one who did the DUR not
The one who did the DUR alert for when the DUR alert fired for the duplicate therapy is not Mr. Hetherington.
Okay.
Mr. Hetherington, unfortunately, was the unfortunate individual who dispensed the 75 when it came up for ready fill.
Is there a CVS policy in the instance when the DUR was addressed to deactivate the original prescription?
When you say there's a policy that they're supposed to do something. They're supposed to take some activity. They're supposed to call the doctor or talk to the patient or the patient's caregiver, which they did. Now, does our policy specifically say you must deactivate if there's a duplicate? Well, again, sometimes you're on multiple strengths. So, but you're supposed to clear it. The pharmacist did clear it, but the pharmacist then didn't deactivate where there was a duplicate therapy, where they were told, I'm assuming they were told because the patient came back and said, I got a 75, I shouldn't be. I'm assuming they were told that they shouldn't be on a duplicate therapy.
So just to go a little further on this discussion. So if the pharmacist calls the doctor and identifies that the 75 milligram should be discontinued, then there's no policy that directs the pharmacist to actually do that then?
The pharmacists are supposed to clear the patient's profile and do what the doctor wants. That was not done in this place. I will not tell you that the pharmacist didn't do something wrong. And I'm not pointing fingers. It's a human error. I don't know what they were thinking, but they did not get deactivated at that point, which is why the 75 microgram got filled a little less than 3 months later.
But that wasn't this pharmacist. That was
not Mr. Hetherington, no.
So I know, like in a DUR, they have to set kind of when the DUR trigger. Like some of them, if the medication is year-old, you don't need DUR, right? For that, some of them is not been used for 90 days. They don't trigger DUR. I mean, it's go through the process, but it doesn't flag. You know what I mean? So if you did like clinical review or DUR once, you don't need to do it like every time. Otherwise, there'll be like fatigue. So I see this process, very common process with community pharmacy and hospitals sometimes.
The system always DUR.
Yeah, it's always DUR, but what they show to the user, it is,
Correct.
you know, what I mean, is different.
As someone who takes thyroid medicine and my dose bounces around all the time, I would be probably pretty irritated if my prescriptions were discontinued, because I would go back and refill an older strength when my strength got changed back. You know, I'd have 4 or 5 different active prescriptions on file. Of all the medications that exist out there, levothyroxine seems like the most likely culprit in this particular example.
And warfarin and levothyroxine. There's some medications patients can be, but it's addressing the complaint here. From my opinion, that the pharmacist listed here, I mean, did their job. There's nothing alert him to act or to discontinue or whatever action he's supposed to do. CVS system, I mean, they do like 1 million of prescriptions a year, I mean, a month. So I believe the DUR system, I cannot question it, to be honest. me personally, you know what I mean? Whether or open a complaint against the other pharmacist, the first pharmacist. I don't know if this is needed at this point.
I think I'm tracking with you, and
Yeah.
I would dismiss both.
Yeah, I
think
mean,
we
that,
brought
yeah.
you here, you explained the DUR
Yeah.
did happen and how it works. I think that's what the concern was. And I would make a motion to dismiss.
Second.
For
I have a
both
question.
parties.
Yeah. That's what I were going to, like, to dismiss both, but the question about the first pharmacist, do we need to address it or not? Yeah, yeah.
I have a question for Mr. Hetherington.
Yes.
You hear me?
Yes. Can you hear me?
Yes. So are you aware of any other instances in your practice where the auto refill feature has caused you difficulty in your practice in terms of patient safety?
In terms of patient safety, the auto refill was actually more frustrating prior to the smart DUR system because there were basically anytime it filled, a DUR usually popped up regardless of how long they were taking it. The smart DUR system tried to lessen that, and they updated an option to inactivate prescriptions at the register to assist with that. So honestly, at least for me, I tried to make sure I would ask the patient if they want me to discontinue it before I discontinued it, just to make sure nothing bad happened. But as far as like being concerned about patient safety, no, it was never something. Usually, if there was something concerning, the system would force stop or require documentation that either why we didn't bring it up or talk to the person at the register and document what they discussed.
Thank you.
Okay, so I think I have a motion to dismiss both. Did I have a second?
I second.
Yes. Okay. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Appreciate your time on this. Item 21C, Brian Cho and CDS 2368.
Dr. Gandhi, I have my current PIC who's not asked to come in. I have him on the line also. Could I just send him a text message and he'll come in? That is
We want to have people introduce themselves, starting with Mr. Jacobson, please.
Matt Troyer. You have that. Thank you.
He's on.
Yep.
Go ahead, Max.
Hi, I'm Matt Troyer. I'm Matt Troyer. I'm the current new pharmacy manager at store 3268.
Thank you. Mr. Jacobson, if you want to introduce yourself, and then we'll go to Mr. Convery, and I think we've got Mr. Cho on the line as well.
Sure. Thank you. Max Jacobson, compliance officer with the Board of Pharmacy.
Good afternoon, all. Once again, Brian Convery. I am here as a representative of CBS 3268.
Hello, Brian Cho, pharmacist.
Welcome, Mr. Jacobson. If you could give us a summary, please.
Yeah, thank you. An employee was filling in at this pharmacy and submitted this complaint to us after seeing the condition of the pharmacy. The complaint stated the conditions were appalling. The complainant pointed to examples of pills and trash that formed 1/2 to 1 inch thick barrier around the pharmacy. The Kirby Lester device was so dusty, the clear tray looked solid. And the complainant referred to several other examples of uncleanliness, including pill dust and pills being everywhere, and patient safety concerns due to cross-contamination. The PIC stated in a written response that he does not agree with the length of exaggeration the complainant relayed, but did acknowledge that there were staffing issues with a busy winter season that had led to neglect in certain areas of the pharmacy. The PIC stated as of the writing, when I wrote this response, that the pharmacy is now clean. Furthermore, cleaning issues have been addressed with the staff as the PIC agreed that more diligence is needed for a clean air environment to lessen the chance of patient harm. I've included in your board book pictures of before and after cleaning, and I hope you've had a chance to look at those. I conducted on-site investigations after receiving this complaint, and then once again after the PIC reported it was cleaned, and the evidence is based on those pictures. I think you'll find those pictures and the findings kind of speak for themselves, as there was maybe some improvement, but in my opinion, it wasn't vastly improved. My last little note here, I guess, is about the previous routine compliance inspection. Had needs improvements in several areas, including cleanliness.
Thank you, Mr. Jacobson. Mr. Convery, Mr. Cho, Mr. Troyer, do any of you wish to address the board before we proceed with questions?
I do not, Ms. Momsley. Ms. Momsley, I'd be happy to take questions.
Same.
All right.
I have no other stuff.
Okay. Board members, discussion, questions?
What's their plan going forward to keep the pharmacy clean or to make it cleaner?
Of course. Mr. Troyer, who's on, is the current PIC, has been there since I believe April. I believe he can speak to that as current boots on the ground.
Yeah, I sure can. So yeah, like you said, I'm current pharmacy manager, started in mid-April. I have first trained the existing staff on expectations and how to clean the pharmacy, regular expectations, cleaning each section. We're doing it while we do outdates, when we're checking for expired product. At the same point, cleaning shelves, that was a major issue there, was cleaning the shelves. So that's being done on a regular scheduled basis. Same time as just general cleaning in the pharmacy happening, daily, making sure, floors are clean, counters are wiped down, trays are cleaned often throughout the day, and just making sure that staff understands what is expected, and teaching them that. To address just the staffing level, I have transferred in some technicians from other stores that have done well in the past, that have clean, positive environments. I've brought on technicians to assist my team, not only in training them, teaching them what's right, but also just to help this pharmacy moving forward. And that's really what we're doing, is just kind of making this a point of emphasis that this is required. This is something important to do every day. It's just as important to take care of our patients, to be in a clean environment.
Did you have to replace any of the Kirby Lester? It kind of looks like the counting portion maybe needed to be replaced, or it was just dirty. I can't tell.
Yeah, so they had done a deep clean before I actually got to the pharmacy, so it wasn't in the state of the pictures when I got there. But no, I haven't replaced anything like that since I've been there. The Kirby Lester unit does function normal. We do daily checks on it of cleaning it and then documenting a count to make sure it is accurate. And we've had no issues with accuracy there.
Yeah, the trays just become foggy like easily. We use those. We try to clean them very well. Still the same. Yeah.
Mr. Jacobson, have you been back since the new PIC started?
I have not. I was actually just notified of Dr. Brian Cho's termination and the new PIC recently. I'm not sure when he actually took over.
What was the date, Max, that you did your follow-up review?
Yeah, the date that I did the follow-up review was January 16th.
Mr. Cho, could you just tell us what the work environment, what it led to this? I mean, why you did not?
I wouldn't say, yeah, I got you. I wouldn't say it led to it. Probably just patterns, but I wouldn't say in terms of a deep clean, it would take after hours, right? Once we open, we're staffed. it would be impossible to do like a full deep clean in terms of every crevice and whatnot. But in terms of like patient safety, all that stuff, we did address it. It can take like one really bad week to kind of, I guess, make it look like a disaster zone, which it was a pretty rough flu season there, but it's just one of those things.
But from your previous inspection that mentioned, so to me it just wasn't only a one week, like busy 1 week. So when it shows in your inspection as need improvement, the inspection, it is not violation yet, but it needs improvement. So we need to improve it, right? It's not something, oh, it is, it just needs improvement. It's not just needs improvement. You need to act on it. So, I mean, I see like, like I would accept and understand that, like a busy couple days, 1 day or 2 weeks, you know what I mean? But to get to level of employee complaint or comes to your report, it's not only 1 week. It is basically, it is not important for the staff there to clean up the place, right? And cleaning the pharmacy, it is listed in our state rules, part of the law, that is a job of the PIC to take care of the pharmacy. It is important as much as controlling your medications. It is the same important. It is listed in the rules. It is part of our patient safety, our public safety. I just want to mention that to you. You know what I mean? It is not a simple violation that, okay, it is just need improvement. Just, I'd like to mention that to you.
And you're no longer employed with CVS?
Currently not, no.
What was the reasoning for the parting of ways?
Just termination.
What led to the termination?
Oh, I guess technically theft, but that's something that's open and that's being worked on right now.
I'm sorry. So currently you don't work currently? Like you're looking for a job?
Currently, no. I'm just enjoying my time right now.
Mr. Cho, did you say that you were terminated by CVS for theft?
Correct. There is actually a
open
request for a written response from, I think I saw Miss Brown earlier.
Oh, okay. From the board. Okay.
Yeah.
So are we aware of this yet?
It sounds like we are.
Would defer that to Ms. Brown.
So we're just discussing this issue now, right? Okay.
Yeah.
So I don't know. I mean, we can't discuss this anymore. It is obviously like a person failed to maintain their pharmacy to be safe to practice. I don't think the permit holder has anything to do with it. I mean, they hire people to do the job and they fail to do the job. So I move to dismiss the permit holder, and this is a violation, just not maintaining the pharmacy, and because it's part of our law requirement, it is listed and it is responsibility for the PIC. I just feel like 3 hour and get to the point like there is a complaint, right? It is like very visible. I'm okay with 3 hours, continuous education in law. I will do like a non-disciplinary action, just like, unless somebody has.
I don't know if I agree with that. I do think the permit holder has some responsibility, especially when it's a repeat of a violation like this. And I also feel a little differently the fact that it was a repeat violation and it was still in a state that wasn't acceptable. So I don't know if I can support that.
But I mean, so what if he doesn't tell them what's the finding? I mean, like, do you need the permit holder to come just routinely to?
Does CVS do like district manager check-ins with pharmacies, I assume?
We do. The district manager and this specific store, he inherited this store in January, and the new PIC took over in April. So he had only been in charge of the store
That fair?
January, which was Mr. Jacobson had said was the last time he had been there. So he only picked up that store at that
So-
time.
Yeah, so it's fair. I will add to my motion a letter of concern to the permit holder regarding keep clean place.
Do we want to take this separately, one motion for the permit holder and one motion for the others?
Yeah. So my first motion, it's for the pharmacist in charge. It is 3 hours continuous education on law,
That's Mr. Cho.
non-disciplinary. I mean, I was thinking, I saw you you may disagree. You can please oppose. If you disagree, please do it right now.
Which
Before.
pharmacist in charge?
Mr. Cho.
Mr. Cho.
The
The
listed
listed.
one has helped clean it up.
Yeah,
I,
listed one.
he can speak to that, but I
So please, if you disagree with that.
I do disagree. I
Okay,
do feel
just-
like
yeah.
discipline would be appropriate
Okay,
because
I modify my,
state.
yeah,
Yeah.
I modify my motion to be a discipline. Discipline, yeah, 3 hours, the discipline. So you have to second it because you made me.
I'll second that.
Okay, thank you.
The only other thing I was thinking about is maybe for the permit, I know we kind of already went over that, but I was also thinking about a reinspection at their
But,
cost.
yeah, but this is.
I think we were taking those separate.
Yeah, we're taking it separately. Okay.
So I believe Mr. Thorwald seconded the motion, and that is for Mr. Chow, 3 hours of disciplinary CE in law.
Correct. That's Hogan.
I'm sorry.
I'm just gonna throw this out here. I don't know what he's gonna learn from law CE.
But
I
it is-
agree. I agree we need to do something, but I don't know that CE is gonna teach him anything. Like, that's pretty basic to think that you have to keep a clean, neat, organized pharmacy. I mean,
It is very basic, and I mean, I agree with you, but I mean, but we need to do something just to send a strong message. It is more than like education or educating the person. I mean, it is just, from my perspective, a strong message. This is important, right? It is not just something can be missed.
I don't think law covers it, but is there something related to hygiene, cleanliness? It just, law doesn't seem to fit for me.
Okay, unless, I mean, we can go. It is so basic. There is nothing can cover it. You cannot ask person to wash your hand after you eat and before you eat. I mean, it is basic. I totally understand. The whole point, like, it's just to send a strong message. It is discipline action. It's not something, you know what I mean? And this is,
okay. Well, we have a motion in a second. Dr. Gandhi, you want to do a roll call?
Certainly, Madam Chair. Mr. Thorwald,
Aye.
Ms. Nair,
Nay.
Ms. Davis,
Aye.
Ms. Walmsley,
Nay.
Ms. Park,
Aye.
Mr. Hogan,
Aye.
Mr. Al-Nasif.
aye.
5 ayes, 2 nays, and 2 absence, Madam Chair. Ayes have it.
Thank you, Dr. Gandhi. And now let's go to the permit holder.
I'll make a motion for an inspection at the permit holder's cost.
Second.
Is that in the, like in an order or something like that?
That would have to be a consent agreement, Madam Chair.
Yeah, before we move for this, are they scheduled any soon? I don't know, we don't give them date to be inspected, like as routinely?
I don't believe they are. I believe they were inspected September of 2024. And
Oh, yeah, who knows? Yeah.
yeah, so I don't believe it would be coming up in the next couple of months at least.
I mean,
What about a non-disciplinary letter of concern, so it's memorialized?
that's what I agree with, because, yeah.
But because if we require an inspection, then that'd be disciplinary.
Which is, I don't think that's, yeah.
I'm comfortable with my motion.
I'll second that.
That was for a consent agreement to order a repeat inspection.
Yes.
Is that correct?
Yeah,
That is correct.
that's correct.
Yes.
Okay, Dr. Gandhi, do a roll call, please.
Mr. Thorwald,
Aye.
Ms. Snare,
Aye.
Ms. Davis,
Nay.
Ms. Walmsley,
Nay.
Ms. Spark,
Nay.
Mr. Hogan,
Aye.
Mr. Al Nassif.
Nay.
Motion fails.
I'll make a motion to issue a non-disciplinary letter of concern regarding the state of the pharmacy.
I second.
We have
I have a motion and a second. Any discussion?
I think that I would feel better knowing that the pharmacy's taken the actions that we've been told that they have, because this was a repeat violation. We went back to the pharmacy and it was not up to the standard we wanted to see. Now we've been told that it is, and we would like to see that it is for ourselves. And our inspector needs to come in and see that what they've said has taken place has.
Madam Chair, if I may,
Mhm.
if the board does vote for non-disciplinary and Ms. Nair brings up a good point, historically, we have kind of looked at the permit holder and says, would you request an inspection to get it on record that they would, so that we can move forward with non-disciplinary and still get an inspection in. But it would be a verbal agreement that they would bear the expense. So, I mean, and statutorily, it says if they request it, we can still charge them. And I don't know if that's going to be in the middle there between discipline, non-discipline, and so forth.
Mr. Convery, thoughts?
It is a repetitive violation for the same pharmacy, or I'm saying, like, what's your concern? You said, like, it's not the first time. It is repetitive. It is for the same pharmacy, or yeah.
And it's the same pharmacy, and now they have a new pick who says that they've cleaned it up.
Yeah.
So we want to see that they have. Are you able to comment?
I was just waiting. I mean, we would welcome the board coming in and validating what we've said with regards to the cost of my understanding is that the board is welcome to come in anytime they want, even though it might not be on a regular cadence. We understand that the board could come in tomorrow and come in again next week and come in again the week after.
There's a cost for our inspectors, so if it's not within their regular routine, they would we're asking if you would be willing to do that and kind of meet us in the middle.
I would be willing to do that. As I said, we would welcome the board. I've spoken with Mr. Troyer about this. Mr. Troyer, you could ask him. He's the boots on the ground. From my standpoint, we would welcome the board coming in to reinspect.
I don't know how to phrase that, and I think there's already.
If I may sum it up. So I think the discussion is a non-disciplinary advisory letter for cleanliness. And then at the permit holder's request, do an inspection, unannounced inspection, at their request, based on this agreement, at their expense.
So moved.
Was there already a motion though on the table?
I just want to.
Maybe amend the motion, or
Well, I'm going to throw it back out of Mr. Convery. Do you agree that's what the discussion was?
I believe that's what the discussion was. I'm not sure if it'll be memorialized that way, but I agree that that's what the discussion was.
I don't recall we were. Was there a motion made
There
and
was-
now we're amending it?
Yeah, there was a motion made to issue the non-disciplinary advisory letter regarding the condition of the pharmacy. I would view that a friendly amendment to acknowledge that the permit holder has requested that the board conduct an unannounced inspection at their expense.
I'll edit my motion to include that friendly amendment.
And then Mr. Olson seconded that.
All right.
Just to have it convey the discussion.
All right. We have a motion and a second. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Thank you for your attendance today.
Thank you all.
We are going to 22B next. Discussion, consideration, of possible action regarding the request made by Bong Ho. We have a echo.
Yes, I'm here. I'm sorry.
Okay,
Can
that's
you hear
better.
me?
Yes, if you
What item number?
22B.
Yes. My name is Fang Ho, and I'm a pharmacist.
Madam
Sorry.
Chair, I believe I'm recused from this one.
Okay, thank you. Miss Brown, I think we've got at the table. I can't tell from the back. I think it is Miss Brown. If you could please give us a summary of why he's here before us today.
Certainly. And you're correct. Jenica Brown, Executive Assistant to the Deputy Director. Fung Ho was issued an Arizona Pharmacist license by Reciprocity on December 27th, 2012. His license expires on October 31st, 2025. It is currently open and on probation. On or about July 27th, 2022, Mr. Ho contacted the board to report that he had written a prescription for a medication under a doctor's name that was not authorized by the doctor. On or about July 28th, 2022, the board received notice that Mr. Ho was terminated from employment at Fry's Pharmacy on July 27th, 2022, due to the alleged prescription forgery, fraudulent activity, and theft. According to the notice, a medical provider notified Fry's that a prescription for a controlled substance had been written and filled under his credentials without authorization. Through investigation of this claim, Fry's discovered that Mr. Ho had written numerous prescriptions under the same doctor's prescriptive authority for both himself and a pharmacy technician. In his verbal and written statements to board, Mr. Ho indicated that he provided the controlled substance to a technician in the parking lot after his shift, and that the medication was filled under that technician's name and billed to the technician's insurance. However, in his statements to Fry's Pharmacy, Mr. Ho indicated that he did not give the medication to the technician, but rather ingested it himself. On September 7th, 2022, Mr. Ho entered into an interim consent agreement for interim suspension of license and evaluation. The board considered the matter along with the results of the evaluation and voted to offer Mr. Ho a consent agreement and order for suspension, lifting of the suspension, probation, continuing education, and civil penalty, which was executed on June 16, 2023. The consent agreement placed Mr. Ho's license on probation for a minimum period of 2 years and required payment of a civil penalty in the amount of $900 and completion of 9 hours of continuing education in the area of pharmacy law, with at least 3 hours in the area of federal pharmacy law. Mr. Ho complied with the civil penalty and continuing education requirements outlined in his consent agreement. Supporting documentation is included in the board's files for consideration. On or about November 26, 2023, Mr. Ho contacted staff to inform the board that he had entered into a plea agreement with the Arizona Superior Court, and as a part of the agreement, he would be placed on probation for 18 months. Staff obtained documentation of a direct indictment charging violations of the following. Count 1, fraudulent schemes and artifices, a Class 2 felony. Count 2, forgery, a Class 4 felony. Count 3, obtaining or procuring the administration of a narcotic drug, a Class 3 felony. And Count 4, obtaining or procuring the administration of a prescription drug, a Class 1 misdemeanor. Documentation provided by Mr. Ho indicated that he pled guilty to Count 4 amended, transfer of a prescription drug, a Class 6 undesignated offense. On November 16, 2024, Mr. Ho contacted staff and provided documentation indicating that the probation in his criminal matter was terminated early on November 7, 2024. On January 8, 2025, Mr. Ho submitted a written request to appear before the board during the June 2025 meeting to request termination of his probation. On June 11th, 2025, Mr. Ho contacted board staff and submitted a character reference letter from his pharmacy supervisor. It is included in the board's files for review. Of note, the letter was submitted by Mr. Ho himself and not the supervisor. Mr. Ho is in compliance with the terms of his consent agreement, and there are no concerns from staff.
Thank you, Ms. Brown. Mr. Ho, would you like to address the board, or would you like us to proceed with questions?
You can proceed with the questions. Yes, whatever you have asked for me. I can make a short statement if you want. What I have learned from this.
Yeah, that would.
experience.
I would like to hear that. Thank you.
Yes, ma'am. I have taken full responsibility for my actions and deeply reflects on my professions. This experience taught me the critical importance of maintaining the highest standards of ethical professional conduct at all times. I have learned to be more vigilant, thorough, and proactive in ensuring compliance with all pharmacy law and regulations. Since the incidents, I have taken concrete steps to grow, include complete continuing education course focused on ethics and professional accountability, and implementing a personal system to double check my works. Most importantly, I have regained a renewed sense of responsibility to the community and the trust placed in me as a healthcare professionals. I'm committed to applying these lessons to my practice moving forward, ensuring that nothing like this will happen again. I've been practicing working at Visits in Need Community Health Center for a year now, and my supervisor, as you can see, and character statement back me up. Yes, ma'am.
Thank you, Mr. Ho. Board members, any additional questions for him?
I appreciate the synopsis of what you've learned and what you've gone through. It looks like you fulfilled all of the obligations, and I would approve the termination of the probation.
I appreciate it, ma'am.
We have a motion and a second. Any discussion? All those in favor? Aye. Any opposed? Hearing none, motion carries. Thank you, Mr. Ho, for being present today. Glad to see that you're doing well.
Ms.
Thank you, all members.
Yes. I'm sorry, what was that, guys?
There was one nay, just for the record. I don't.
Oh, thank you. Thank you, Mr. Ho.
Thank you, ma'am. Thank you, madam.
22C, Taylor Jean Ashley.
Madam Chair, I'm also recused.
Thank you. Is Miss Ashley present? There she is. If you could introduce yourself, starting with Miss Brown.
Jenica Brown, Executive Assistant to the Deputy Director.
Taylor Ashley, Pharmacist.
And Jim Corrington, licensed clinical social worker with the PAPA program.
Thank you. Miss Brown, if you could give us a summary, please.
Taylor Ashley was issued an Arizona pharmacist license by full exam on July 29th, 2019. Her license expires on October 31st, 2026. It is currently open and on probation. On or about May 9th, 2022, Fry's Pharmacy contacted the board to report an incident involving Miss Ashley in which she was observed to be impaired in the workplace on March 9th, 2022. As a result of the concerns, a drug screen was initiated by Fry's and Miss Ashley took a leave of absence. Upon returning to work on May 9th, 2022, Miss Ashley was placed on a suspension as the for-cause test results were positive. She admitted to taking an old prescription that she had at home. She indicated to board staff that the prescription she took was previously ordered by a provider and dispensed by a pharmacy located in Arizona around the time period of 2011 to 2012, and that she took it to try to alleviate stressors in her life. Miss Ashley provided board staff with a 5-page letter explaining the events leading up to and including the incident at Fry's on May 9th, 2022. The information detailed in the letter raised concerns about her ability to safely practice. On or about June 29th, 2021, 2022, the board issued an interim order to Miss Ashley for an evaluation. She complied with the interim order, and on October 5th, 2022, Miss Ashley entered into a consent agreement for probation and monitoring, which placed her license on probation for a term of 12 months. The agreement required her to meet with a board-approved specialist at certain intervals and ensure that the specialist provides quarterly reports to the board relating to her care and treatment. Ms. Ashley failed to seek board approval of this specialist, and she failed to ensure that the specialist provided the reports to the board in a timely manner. At its December 2022 board meeting, the board considered Ms. Ashley's application for the renewal of her pharmacist license. In addition to considering possible violations of the consent agreement, the board was presented with investigative information related to her recent termination from Fry's Pharmacy for taking her own verbal orders for a prescription, performing the initial data entry, pre-verification, drug utilization review, and verifying 5 fills of the medication from September 22nd, 2022 to October 30th, 2022. During this time period of 38 days, Ms. Ashley dispensed to herself a total of 479 tablets of the medication. This averages to just over 12 tablets per day. The prescriber's daily reference states that the maximum daily dose of this medication is 6 tablets per day. As a result of this new information, on February 16th, 2023, the board and Ms. Ashley entered into an interim consent agreement for interim suspension of license and evaluation. She timely complied, and after review and consideration of the matter, the board voted to offer Ms. Ashley a consent agreement in order for terminating suspension of license and imposition of probation with monitoring in board case number 22-0717. The agreement became effective on June 19th, 2023, and placed Ms. Ashley's license on a probation for a period of 2 years. In addition to standard terms, the consent agreement required Ms. Ashley to enter into a monitoring contract for the entire term of her probation, attend weekly relapse prevention meetings, and continue to see her board-approved therapist and psychiatrist and ensure that the specialists provide quarterly reports to the board. On May 2nd, 2025, Ms. Ashley requested an appearance before the board to request the termination of her probation. Included in the board's files for review and consideration are letters of endorsement from PAPA, in addition to the quarterly reports from her providers. Ms. Ashley has complied with the terms of her consent agreement, and staff has no concerns.
Sorry, it would help if I unmute myself. Thank you. Ms. Ashley, would you like to address the board?
Yes, so thank you for having me here today. Through my journey, I've learned to cope with my anxiety and depression in better ways. I've gained a social network through friends, work, going to meetings, and through my home group. I've increased my hobbies such as reading, painting, and journaling. And through my experiences of the program, I've grown as an individual and a pharmacist as well.
Thank you. Mr. Corrington, you're supportive of this request?
Absolutely, and so is Ryan and the PAPA program. I saw Taylor 1 hour a week the entire time she's been in PAPA, and she's made terrific progress, assumed full responsibility for what happened in the past, and moving forward to stay on track for the rest of her life. And that's what we do in that group is figure out how to set up a series of actions that'll create a surety of staying on the right track. And so we fully support Taylor in removing the probation, and that's why we're here to celebrate her success and the PAPA's success and her being in recovery and helping other pharmacists who are going to come in behind her that have had the same issues.
Thank you, Mr. Corrington. Ms. Ashley, I'm glad to hear that you're doing well. Board members, do you have any questions for Ms. Ashley?
Did you hear that, Ms. Walmsley?
No, I did not.
We have mic issues, yeah. I just make a motion to accept her request.
And I second it.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Thank you, Ms. Ashley. Glad to see you're doing well, and congratulations. 22D, Fernando Esteban Frias Hernandez. Welcome. If the parties could please introduce themselves, starting with Ms. Brown.
Jenica Brown, Executive Assistant to the Deputy Director.
Fernando Frias, Pharmacy Technician.
Ms. Brown, if you could give us a summary, please.
Fernando Frias Hernandez was issued a pharmacy technician license on December 25th, 2021. His license expires on October 31st, 2025. It is currently open and on probation. On November 9th, 2023, the board office received a notification from the Department of Public Safety stating that Mr. Frias Hernandez was arrested and/or fingerprinted for 2 counts of misdemeanor DUI. The date of offense was December 3rd, 2022. Staff searched for charges that may have been filed against Mr. Frias Hernandez online and discovered that he had been charged with DUI, alcohol, drugs, toxic vapor, and DUI drugs or metabolite. Mr. Frias Hernandez did not notify the board of the charges filed against him within 10 working days. On November 20th, 2023, staff sent Mr. Frias Hernandez notification of a complaint along with a subpoena for records. Mr. Frias Hernandez responded and stated that a police officer had stopped him for speeding and determined that he was under the influence. However, Mr. Frias Hernandez denied that he was under the influence. The police report provided by Mr. Frias Hernandez stated that he admitted to smoking marijuana daily and that he had used marijuana on the day that he was arrested for DUI. The report also indicated that his blood test resulted in a positive result for marijuana. On his September 2023 license renewal application, Mr. Frias Hernandez answered no to the question whether he had been arrested, charged, pled guilty, or convicted of a felony or misdemeanor offense since his last renewal. He did not disclose his December 2022 arrest. When staff asked him why he did not report his arrest on his renewal application, he stated that he was taken to provide testing but was not charged, so he did not believe that he had been arrested. On February 21st, 2024, the board issued an interim order for evaluation. Mr. Frias Hernandez complied with the order and subsequently entered into a consent agreement in order for probation of license with monitoring. The agreement became effective on June 28th, 2024, and placed Mr. Frias Hernandez's license on probation with monitoring for a minimum period of 1 year with standard terms. On May 5th, 2025, Mr. Frias Hernandez requested an appearance before the board to request the termination of his probation. Included in the board's files is a letter of endorsement from PAPA for review and consideration. Mr. Frias Hernandez is in compliance with his consent agreement and staff has no concerns.
Thank you. Mr. Hernandez, would you like to address the board?
Yeah, I just want to thank everybody for taking the time and the opportunity to review my case. I do want to say that this year, it has had a positive impact on me, considering that I've been sober for the year and going on forward, along with it just having a positive outlook in life and just this whole situation. And hopefully, this can be put behind and, not be presented here in a negative matter, hopefully in a positive matter if I ever do come back.
Thank you. I appreciate that. I'm glad to hear that you're doing well. Board members, do you have any questions for Mr. Hernandez?
No question. I'll make a motion to terminate the probation.
Second.
A motion and a second. All those in favor? Aye. Any opposed? Hearing none, motion carries. Thank you, Mr. Hernandez, and wish you continued success.
Thank you. If I may, I just have a quick question. Just to clarify, my agreement still goes until the date on the paper, correct? So up until then, I still do daily check-ins and all that.
Yes, we're just lifting the probation.
Okay, perfect. I just wanted to verify that. Thank you very much.
Thank you. Next up, 22E, Chad Harrison. Request to lift termination, to terminate probation. Welcome. If the parties could introduce themselves, starting with Ms. Brown.
Jenica Brown, Executive Assistant to the Deputy Director.
Chad Harrison, Pharmacist.
Jim Corrington, licensed clinical social worker with the PAPA program.
Thank you. Ms. Brown, if you could give a summary.
Chad Harrison was issued an Arizona Pharmacist license by Score Transfer on February 28, 2011. His license expires on October 31st, 2026. It is currently open and on probation. On or about August 17th, 2017, Mr. Harrison was indicted on 2 counts of fraud, possession of a controlled substance, both second-degree felonies from the District Court of Collin County, Texas. It was alleged that Mr. Harrison obtained a controlled substance and a prescription for a controlled substance that were not medically necessary and in an amount that was not medically necessary from 2 different practitioners by misrepresentation, fraud and forgery, deception, subterfuge, and concealment of material fact. The acts were alleged to have occurred on August 18th, 2016 and December 30th, 2016. Mr. Harrison did not disclose the indictments to the Arizona Board within 10 days. According to court documents, on or about November 19th, 2019, Mr. Harrison entered into a plea of guilty of fraud, possession of controlled substance. The court further entered an order deferring adjudication and placed Mr. Harrison on probation for a period of 2 years, subject to certain terms and conditions, including requiring him to forfeit his Texas pharmacist license. On or about October 25th, 2018, Mr. Harrison submitted his application for renewal of his Arizona pharmacist license and disclosed that in August 2017, he had been charged in Texas with doctor shopping a controlled substance. He noted that the charges were still pending and that he was seeking dismissal. On or about December 10th, 2019, Mr. Harrison entered into an interim consent agreement and order for voluntary suspension with this board. Mr. Harrison appeared before the board in May of 2020 to discuss the pendency of his application and the events that occurred in Texas. The board voted to table the matter for the purpose of obtaining additional information from the Texas Board of Pharmacy. Additional research by staff revealed that Mr. Harrison had been involved in the theft of a controlled substance from a Texas pharmacy where he worked. He made this disclosure to an investigator with the Texas Board in June of 2018. After being given several opportunities to make this disclosure to the Arizona Board during the May 2020 meeting, Mr. Harrison failed to do so. After the May 2020 meeting, board staff also learned that in 2012, Mr. Harrison was charged with assault. It is unknown whether he disclosed the charges in his 2012 or 2014 renewal applications, or whether he disclosed these charges to staff. The board considered his matter during the July 2020 board meeting and voted to offer Mr. Harrison a consent agreement and order for probation and monitoring. The agreement was executed on July 15th, 2020, and placed his license on probation for a period of 5 years. Along with standard terms, the agreement required Mr. Harrison to enter into a rehabilitation and monitoring contract for the entire term of his probation. Staff received a copy of his contract with PAPA, which was dated July 15th, 2020. Mr. Harrison contacted board staff on May 8th, 2025, and requested to appear before the board to request termination of his probation. Staff received a letter of endorsement from PAPA, and it is included in the board's files for consideration. Upon reviewing Mr. Harrison's matter to determine compliance with his consent agreement, it appeared to staff that his employer may not have submitted a written acknowledgement indicating that they received a copy of his consent agreement as required by the agreement. Staff requested further information in this matter and received a faxed letter dated with 2 dates, September 4th, 2020 and May 13th, 2025, from the PIC at his place of employment. Staff further requested a fax receipt from 2020 to support the date that the letter was initially sent. The PIC subsequently forwarded an email from August 4th, 2020. The email was from Mr. Harrison to the PIC asking that he sign and send the letter to the board. In his email to staff, the PIC attested to mailing the notice to the board on August 5th, 2020. This communication is included in the board's files for review and consideration. Mr. Harrison appears to be in compliance with his consent agreement, and staff has no further concerns.
Thank you, Ms. Brown. Mr. Harrison, would you like to address the board?
Hello, thank you for allowing me to be here. Everything she said was true. Feels like a different life. I'm here now. It's been a great experience being in the PAPA program. I feel like I'm a different person, so I would be thankful to get my license off probation if possible.
Hello again, Jim Corrington, licensed clinical social worker with PAPA, and Chad is a group leader He's been in Papa for 5 years every week. I see him every week for an hour. He has successfully entered not just in recovery, but he's been a single parent of 4 children the entire time he's been in Papa and in recovery. And he's been able to navigate all of the tasks of being in recovery successfully and raising 4 children. And those are his top priorities. And it's never wavered since I met him. And he's a great example for these new people that are coming in and they're kind of lost. And they see that he has come this far. And that's the whole reason for the Papa program, is professionals assisting other professionals. So we fully support him. Ryan does from afar. He couldn't be here today, but absolutely 100% support Chad.
Terrific. I'm glad to hear that you're doing well, Mr. Harrison. Board members, any questions or discussion?
I move to accept the request for termination of probation.
Second.
I have a motion and a second. All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Best of luck to you, Mr. Harrison, and your continued journey. All right, let's go to director's reports. Dr. Gandhi.
Thank you, Madam Chair. Lots of activity since last we spoke. First agenda item 23A1. Talk about complaints being dismissed from the last time, March 8th to May 9th. We had 68 complaints that were dismissed behind the scenes. There is a spreadsheet in your handbook with the breakout of types of complaints as requested at the last meeting that were dismissed. The total number does not add up to 68 due to the complaint. Each complaint may have multiple reasons why it was dismissed. So we kind of tallied all those up and created a separate each bucket on why the dismissals happened. Any questions on that?
No, but I do like the new format of the report here, so thank you.
Thank you, Jen. Second agenda item 23A2 is a number of orders for non-disciplinary civil penalties issued with the board's permission or authority given to me was 5 between March 8th and May 9th. As we see more matters, we may see a little uptick if we're seeing simple matters and applications and licensure. So there may be an uptick where we may try to alleviate some things that come before you guys, to give some time back to you guys to address matters that are a lot more critical. 23A3 had an opportunity to attend this year's annual NABP conference in Florida. Tariq was there, Ms. Wamsley was there, Ms. Nair, Ms. Park, and several staff members were there. Really good meeting. I think this was one of, for me anyways, it was one of the more meetings that were more relevant to what's happening across the country. Dr. Daniel Kraft discussed AI and his insight on cutting edge technology that's being reviewed right now. It was mind blowing. There is a link on that first page on that agenda item that will kind of give you a recap of what he discussed. But just to see what's happening out there, wearables, eatables, all these different types of technology that are out there to diagnose individuals is just unbelievable. But that was an amazing. So I encourage you guys to take a look at that link. Other topics discussed was portability of licensure, which I think we've been talking about as well, coming up with a universal law exam so that individuals can move more freely across state lines. Drug Supply Chain Securities Act, as you know, that is in play right now. NABP has a fantastic database called Pulse that we're already leveraging to identify counterfeit drugs out there. Some states have already identified GLP-1s and other drugs that have hit their marketplace that are counterfeit. I think we had one opportunity, but I think we learned about Pulse after that case was concluded to see if there was counterfeit drug involved there. We will present Drug Supply Chain Securities Act and Pulse at the August meeting so that we can, and the audience can become more familiar with what's out there what are requirements and how we're going to be tracking some of those things. Last topic that I discussed was GLP-1s as well. NABP also did an amazing exercise, and I think for a lot in the audience, it was kind of like an aha moment. We've been discussing Just Culture for a while, and I have requests for you here and a couple of more agenda items here, but we had the opportunity to present 2 cases out of our 3 submitted. And it seemed like the board followed the thought process of the decision tree. So it was really cool. I think a lot of states that haven't adopted this philosophy yet were amazed by how methodical it was. I think it was very exciting. It was really cool to see how if this happens, then you do this. If it doesn't, you do that, all the way down the chain until you get to the very end. So it was to me, again, this meeting was more relevant than any prior meetings I've really attended. Any thoughts from other folks that attended would be appreciated.
I would agree with everything you said. I think that Mr. Kraft's presentation was very interesting about what technologies are out there. And this Just Culture decision tree led to several discussions outside of the meetings, and people seem to be liking how it's formatted, that you can kind of follow the decision tree here that's set forth.
Yeah, just to add to that, as a new board member, following that decision tree, it was very impactful, very useful for me as a new board member to go through that exercise and experience that.
Harriet, anything to add? That was also your first meeting.
Yeah, it was my first meeting at NABP. It was, I agree with everything said here, and specifically about AI. I mean, just this is good information for me personally, and I would just encourage all pharmacists to be prepared. I mean, technology is unstoppable. You know what I mean? Now we have rules, and the rules will work together with technology. I mean, eventually, things can be changed, right? So I had a concern. I discussed with other people out of our states about, hey, is it going to affect the demand on pharmacists or technicians or any of this? There is no concern. I mean, that's what they told me, but absolutely the career will be shifting a little bit to more technology, and that will open more door for our pharmacists and technicians to practice. So same thing happening now. If you look at the pharmacy field 30, 40 years ago, is not the same how we practice now. It's just like, so, and I totally was happy with this experience, and then I will try to join again next year.
Yeah, just to sum up what Tariq was saying from Star Trek, it says resistance is futile, right? So you should you should kind of just adopt and integrate with what's coming, because it's coming. So learn it, breathe it, and live it.
Yeah, I don't really have anything else to add. It's always one of my favorite meetings of the year. I'm surprised that I always learn something new. Probably really the major highlight, no, we're going to talk about it again, was the Just Culture presentation and kind of the exercise of looking at some cases from even different states. And would you have made a different decision had you had that algorithm and kind of the decision tree and the way that you look at things? So it was a really good meeting.
Absolutely.
Yeah, and we had a good food also there.
And ABP always does a really nice job with the meetings. They have a great events team.
I should have started with that. Next start with that.
Yeah, you forgot to mention it.
Yeah, I apologize. What else? The other thing that was discussed also, there were, obviously, we vote on resolutions on what NABP can do to enhance the boards and recommendations to the boards. So there were 6 resolutions that were passed during this annual meeting. The first is drug lost in transit. That is on a rise again. I think it tapered off a little bit, but it's going up. One of the asks about to NABP is to work with the federal agencies, DEA, FDA, Postal Service, on how to handle this situation. So more to come on that. Joint accountability. So number 2, joint accountability for pharmacy compliance. So NABP will develop best practices for member state boards on holding owners and or permit holders and a designated supervising pharmacist and or pharmacist in charge jointly accountable. As we know, businesses are evolving. More things are taken more centralized, and the states are seeing that. So the PIC's role is being questioned across the country, whether that's really relevant these days, that position is relevant or not. So that is being addressed. So NABP is asked to take that on as well. Payer processor payment rates and methodologies impacting patient safety. We've been talking about that, and I think it's a focal point across the country about PBMs and how pharmacies are getting reimbursed. Independent pharmacies really struggle because reimbursements are tight, and the only way to sustain them is volume, and sometimes that's not there. So NABP is to look at that as well. Increasing access to medication for opioid use disorder. I'm not sure if you read this morning, but I believe there was an article posted that in 2024, there was a reduction in opioid-related deaths of 24% or somewhere in that range. And one of the attributions to that is making naloxone readily available to those that suffer from this disorder. So good news on that front. Hopefully it continues in that trend going forward. Lastly, on this resolution was task force to examine the use of test of English as a foreign language. So the TOEFL exam is being questioned. I think we've talked about it here at the last meeting and maybe meeting before that. But that is being discussed. So again, more to come on these resolutions as they move forward. Any questions?
I have a statement, not a question, but one of the resolutions that failed had to do with community health workers and maybe how they were going to be regulated is what I think they were going with the resolution. I would love to see that come back. And maybe that's something that can be brought up at District 6, 7, 8. I don't know.
Yeah.
I believe it was about standardized, right? Practice or something. That's a resolution.
No, that was our resolution around creation of a working group to determine why states haven't implemented standard of care. There's another one about community health workers that didn't pass, to Kristen's point, though.
Yeah, we can certainly bring that up at our district meeting. Next agenda item is 23A4. There is a meeting coming up in October. It's an annual meeting with NABP. It's called the NABP Forum, where compliance officers, legal counsel, and board member is welcome to join. There's different timeframes for each, but I think it's a 3 or 4 day long meeting. I believe Mr. Anderson's already threw his hat in the ring there to attend that one. If that's all right with the rest of the board members. Ms. Galvin, I think I kind of nudged you to see if you wanted to go. Indicated yes, you would. So thank you.
That's great.
Yeah, she turned me down like last 10 years in a row, but so Roger, I know how you feel about being turned on from me all the time. Mr. Leong, you're in attendance, I believe, right? And then I will do that as a NABP EC member as well. So next on the list is, you'll see this again, the decision tree. But this is why this is on the agenda is, again, I'm asking for the board to adopt this decision tree as we investigate complaints.
Can I make a comment on that?
Yep.
In my industry, we had something called inter-rater reliability, where we'd have clinical practitioners, pharmacists, physicians, nurses, who would apply clinical criteria to, for example, prior authorization requests. And we would regularly rate the reliability of these individuals, and it would be actually part of their performance review. So we were able to, through continuous quality improvement, really raise the bar in terms of not necessarily ensuring, but making more sure that whether pharmacist A or pharmacist B looked at a particular case, the outcome would be the same. So I very much stand behind this type of activity.
That your motion to approve?
Second motion. Just kidding.
Approve what?
Adopt.
Adoption of the use of the decision tree.
Is that appropriate at this time?
That's my request.
Interesting. Well, I haven't actually studied this specific one. I did read it. I am supportive of this. So I would, to see if it gets
Yeah.
a second, I would.
I
make
mean,
a
I
motion
mean,
to
we did
adopt.
this exercise during the meeting. Yeah, yeah. I seconded you before you because I looked at, I knew you're gonna move for it. So, but just to give you assurance, we went through it. You know, what I mean, we did like a couple exercises during the NABP meeting. It was a great exercise, and I believe this is a good idea to standardize the way we look at incidents and errors, and you know what I mean. So, definitely, I would second you 100%.
So I'd like to make a comment since we have a,
Yeah.
a first
Yeah.
and a second. It's not a panacea. In other words, you need to evaluate it. There needs to be a process of evaluation and modification. So my motion would be that we adopt it as it is, but that we, over time, build a process of evaluation and modification to make sure that it's accomplishing what we need it to do.
No, absolutely. And that's a given. We do constantly
correct.
evaluate behind the scenes, and as we find a better mousetrap, we will present it back to you guys to say, hey, let's amend this and then seek your approval once again. So
Yeah.
that goes without saying, Mr. Hogan.
All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries.
The next on my agenda is 23A6. Every year we have an opportunity to participate with Midwestern about doing a case review with the first year pharmacy students. With me at that meeting, at that discussion was Mr. Anderson, Ms. Snare was there, Ms. Galvin was there as well, and Mr. Morris was there going over a case. And it's very enlightening how these first year pharmacy students look at a case that we've already looked at and adjudicated, right? So we go to a point where a case is looked at and then stop at the very end or throughout the process and say, what questions would you ask? And it's interesting what they ask. And they're pretty much spot on their thought process on what to ask and how to move forward. There's a little hand holding here and there, but very informative, very educational, very eye-opening for these Midwestern students. I have tried to encourage other universities to pick up this practice as well. And they haven't quite adopted it yet, but I'm hoping that they do because, you know, it sees what the board does. It also kind of shows that we're not really out to get people, but we're here to make that relationship assist. And obviously, if there's a public endangerment, we're going to jump in and do something, right? So, but it creates that trust with the board as well. Because I know right now when we do inspections, everyone starts sweating, and we don't necessarily need that to happen. So hopefully this continues and we build a better image out there, I guess, rather than just trying to take people's licenses away. Anything to add, Ms. Nair? Or I'd ask Jeff, but
I agree. It was a great experience. I was glad to do it. I'd be happy to do it again.
Roger, any thoughts before public comment? I know you're going to be up here. Lori, I don't know if you heard, but Roger agreed with everything I said.
That I did not hear it, but that's great. And I agree with you. It's a great exercise. I've participated in it a few times. So hopefully we'll have some other board members have the opportunity to do it again over the next few years. But it always surprises me how good of questions that the students ask. And then also a lot of times they're harder on people than we are, which I think is quite interesting.
Yeah, Ms. Galvin, any thoughts?
I would agree with Lori's assessment. The questions were very good. And you could tell based on the questions that they probably would have been a little bit more hard on the respondent than the board was.
Yes.
Just because you called on me with this one. Historically, we had had the students do this for a number of years. Years ago, the board meeting was actually, you did a board meeting at each of the universities. I think that was before travel costs and video and everything else. But we always checked with the students. The students universally, for at least the 20 years I've been teaching this, are always harsher than the board. They're much more hanging students on anything with that. So I think it's interesting as to what their impression is. I think in this particular example that we did last month, the students actually asked a couple of questions that were good, insightful, that we might not have even thought about at the board meeting. But I mean, we spent 2 hours on one case and they had all the material way in advance in a lot more detail. So it was just interesting.
Thank you, Roger. Next on my agenda is 23A7. I also sit on a national advisory board for U of A. Had the opportunity to attend the meeting. With me were Mr. Hogan and Ms. Walmsley. Ms. Walmsley was just appointed to the board for NAB. So congratulations, Ms. Walmsley. During that discussion, of course, we go over challenges the university college faces. They did get a new president for the university. He's, I think, of an engineering background, so his priorities are not necessarily healthcare, but in a different space. So there's some challenges there. Then we moved on to, of course, the hot topic that we discussed at NABP as well, AI. And then how do we now integrate education into the universities to prepare students to integrate better with AI? At the end of the day, I think we all agree that AI is not perfect today, and it's still ultimately the pharmacist's responsibility to verify all the information that comes out of AI. But you know, these young kids that are in pharmacy school know technology better than probably all of us here at the table. But do they incorporate that into the real life work environment? So there's going to have to be some evolution of training, education, to see how they can incorporate this into their practices. So that's what's being talked about today.
Yeah, at least like they are aware of this challenge because they need to change their method of teaching and educating students.
And I think the second part of that is we had the opportunity to do a sit down with some of the students that are wanting to do more with their career. So they come in, they'll sit down with the different leaders in the room and talk about their practice, talk about their future, what they hope to gain, and the ambition that they have. It's because they're still young. They haven't been beaten up by the real world yet. But it is nice to have that discussion with them. And it kind of invigorates you as well when you're there to say, you know, I'm making a real effort and real change in people's lives. So it is nice to do those kind of exercises time to time, just to bring you back down to earth. Any comments, Chris or Lori?
No, I'll just say that I've been participating in those lunches for about 20 years now. And it amazes me the enthusiasm that these students have. And when you meet them 10 or 15 years down the road, it seems like they're a special group that they've self-selected to really be involved in the profession. And I find that very encouraging.
Perfect. Any more questions on that? The next is a legislative update for you guys. I did share a spreadsheet with you, and I think you have it so that it actually expands and you can actually see updates as the bills move forward. Right now, I think the legislatures are more focused on the budget, and it seems like what I hear last is they're pretty close on coming to a resolution and an agreement on the budget. So hopefully in the next week or 2 weeks, we'll have an idea, and hopefully it's signed and going forward. The new fiscal year does start July 1st. So I think this has to come to a conclusion before that so that we can start off running with the new fiscal year. But just some notable bills is SB 1214, Pharmacist Independent Test and Treat. Yeah, that went through the Senate, and it basically got stuck in the House. And I don't know if it's going to be fast tracked towards the very end here to get to the governor's desk, but hasn't picked up much steam. I know there was a strong push by AZPA, all hands on deck kind of situation. So I don't know if it's going to get the traction it needs to finish cross the finish line this year again. Senate Bill 1235. We were monitoring this one. It's the Health Professional Regulatory Boards Bill. It was the recomposition of the boards to add more public members to it and reduce the number of professionals. That bill died. It failed in the House. So that there's no opportunity for that to come back to life until maybe next year if someone reintroduces it. Senate Bill 1237, state employees remote work prohibition. That was on the radar for a lot of people, including my employees that work in our agency, as well as others. Several years ago, the state kind of consolidated and sold off some buildings. So if this bill did pass, it would have been a real challenge trying to bring everybody back because there's not enough space. So it did fail. It's actually left on a return to calendar. I don't see it moving going forward because there's not an appetite for it. Senate Bill 1377. This is the donation bill, and this is to create more awareness around that. There is a company in Northern California interested. We've been talking to them for a number of years now. And with this awareness, hopefully we can get other folks interested in repurposing medications that are unused in a manufacturer sealed container. So it'll be it's a great bill, great legislation. I just don't think there's enough, I guess, awareness out there for people to expand their operation to allow this to happen. Next one is Senate Bill 1447, Health Board's complaint timeline. That bill did not move at all. As you can see, most boards, I'm sure you can imagine, most boards are opposed to it. Complaints have gotten more and more complicated. This is the second year, I believe, this bill was in play, and it's failed 2 years in a row. But some of the more complex ones, we have shared services. We had one case that had 13,000 pages. We had other cases where we had to get data from wholesalers, insurance companies, and then put it in a way where you guys can digest it so you can make a decision. Some of those complex cases can go beyond the 6-month time limit that they've already set for us, or their recommendation anyways. So it would basically dismiss complaints that are the most egregious, which is what our complaint was with the legislators. Two other bills we were tracking, and they were signed by the governor, is pharmacy emergency authorization, allowing the board to promulgate rules around managing issues related to state emergencies, not just in this state, but other states in our jurisdiction. For instance, what happened with the Baxter scenario not too long ago, where IV fluids were not available or cut short supply. So we got creative on how to remedy that for the health systems in the valley here. But this gives us the authority to make quick decisions to allow for those kind of things that take place. The last bill I want to talk about is House Bill 2628, Pharmacist Emergency Medication Administration. As you know, emergency meds are allowed to be given by pharmacists without a prescription for immunizations. That's been there for a long time. We also know that pharmacists can administer other drugs, but there's no emergency provision when they administer other drugs. So before this bill passed, and it's still not law yet, it won't be law until probably latter part of August or early September, doctors would have to write an order saying, please administer XYZ drug, and then in an event of an adverse event, please administer EpiPen or diphenhydramine or so forth. So they had to put that on the prescription before this bill was introduced. So after this bill goes into law, pharmacists will have the authority to give emergency meds when they administer drugs outside of immunizations.
There is like a list of those emergency medications?
The typical emergency meds, they're outlined in our statutes and rules, would be epinephrine, diphenhydramine.
Okay. Albuterol, like inhaler, or those, none of those are included? Okay.
No. It's anything that creates like an anaphylactic type reaction. Any other questions on any bills I've talked to or any other?
Just for the red cap, this is like have like direct impact on community pharmacy. So this is approved, right? The removing the
That
red cap.
bill did pass where red caps are an option. It's
An
an
option.
It don't have to put it on. The warnings of opioids and the harm it can do still has to be
So
there.
the warning's still there,
Yes.
but the red cap. So now, if I know, like some pharmacies, they have like a lot of lids, like in storage. From the board perspective, do you see an issue if they use it without a warning, just as like a lid for the container?
Some red caps have warnings on already.
Yeah.
Printed on them, right? So you
Yeah.
just have to be careful on
That they can have because it's gonna be mislabeling or yeah.
Exactly,
So as
exactly.
long as there is no warning specific to opioid.
It doesn't
And
say we have
it's-
white lids,
Yeah.
gray lids,
Yeah.
black lids, or
Yeah,
anything
okay.
like that. Yeah.
And it's permissive, so you can still use them if you want to. It's just not a requirement.
Well, I think Tariq is saying to exhaust their inventory, can you put it on any type of medication?
Oh,
Right.
yeah, no, that
Has
wouldn't make sense.
warning on there, right? So,
Yeah.
yeah.
I mean, just the color,
Um,
right, the green one.
Cam, further on that, there is no specific color on the sticker, right? It just has to have the warning, right? It could be white or whatever.
Yep, exactly.
And who determines the recommendation?
For,
On your spreadsheet, there's a column recommendation.
that would be the chair and vice chair.
I can't hear him.
Sorry, Mr. Hogan was asking who makes the recommendation, allowing me to speak on behalf of a bill. with
Oh.
legislators. And so this is voted on before legislation starts to allow chair and vice chair to direct me on how to vote on bills. And so that's who makes those recommendations.
But we also talk about them because a lot of times, Chris, just for your knowledge, the bills are moving so quickly and there's amendments that we don't have meetings in between. So we will talk about sometimes whether or not we want to take a position or not, but the chair and vice chair do it kind of in between because a lot of times Kim doesn't have time to wait for a meeting.
Thanks.
Mr. Gandhi,
Yep.
I know that it hasn't passed yet, but just curious, test and treat, would standard of care for pharmacy technicians cover their involvement there? They would be able to be delegated to help with those tasks. Is that something we'll be considering when we make the rules?
If test and treat does pass, I think we already have that overarching umbrella of what can be delegated and what can't. So I'm thinking that that would fall into that bucket.
Okay, thanks. I was just curious.
Any other questions? Perfect. Next thing on my list is 23A9. As you guys know, the auditors are with us. They become part of the family, per se. Maybe an uncle, a distant one. But I think the bulk of their interaction with us is behind us. They may have some residual questions as they start drafting their report. But I want to thank my team for participating, whether they liked it or not. But I think they did a phenomenal job in interacting with the auditors, giving them the information they need. And we'll see where the chips fall once the report is drafted. We do get an opportunity to review their draft to correct anything that they may have misheard or if my team misspoke. So. Next on the agenda is 23A10. This is going to be on the agenda going forward until final resolutions are done. It's regarding GLP-1s. FDA did put out an update. So on April 24, 2025, the district court denied the plaintiff's preliminary injunction motion in outsourcing facilities associated with the versus the FDA regarding compounding of semaglutide. So the enforcement discretion for semaglutide is behind us. I think the FDA can move forward with issuing observations and so forth if they need to. which falls in line with, I think, our board's decision to kind of move along with the FDA's position as well. And I believe the same thing is applicable to outsourcing facilities because I think they've set those dates. And with this ruling that happened on April 24, 2025, enforcement discretion is behind them. Did I capture that accurately, Ms. Davis?
Yes, basically. So the agency does not intend to take action against compounders for violation of the Food, Drug, and Cosmetic Act from conditions that depend on the semaglutide injection products in the FDA drug shortage list. So it doesn't mean that semaglutide compounding is now against the law altogether, just copies of semaglutide injection products that were previously on the shortage list.
No.
So there might be instances that a patient might need a special dose or combination or titration or something. It's just not going to be to the same scale.
Correct. And I think it's the word is essential copy, right? So it has to be significantly different for it not to be a copy, in essence. Any other questions? Okay. Last thing in my section 23A11 is the rules package that was drafted. I think I captured the essence of the task force members' thoughts and wishes on what needs to be in there. I'm still waiting for the governor's office's approval to move it forward. So they're still reviewing it. I've not heard anything as of this morning. But I would like to let them know that the board is comfortable with moving forward with this bill. Just need their permission before we open it up for public comment and so forth. Just for the board's references, once I get that approval, we move it to public comment. Then it has to go back. If there's no significant public comment, it has to go back to the governor's office for final approval before it goes to GERC. So there's a lengthy process and several steps along the way.
Dr. Gandhi, do you need a motion to go ahead and move these forward if we're comfortable once you get the governor's office approval?
That would be helpful, yes.
Just in case it comes in the next couple weeks.
This lengthy process, what kind of time frame might our licensees expect? Like if everything went smoothly and there wasn't much public comment?
So if I get approval, let's say today, right, then we'll open up for public comment. That would probably take place 30 days from now, 40 days from now. And then sort that out. If there's nothing significant, then we would process with GERC. Well, go back to the governor's office and get their final approval, and that may take another month. So we're already now up to 2.5 months, right? And then go through GERC, and then once GERC approves it, going to GERC may take another month. So we're at 3.5 months. Once they approve it, there's another 2 months, 60 days before that becomes effective. So we're looking, if everything goes smoothly, we're looking at still 5 months. Welcome to government.
Do you want the motion to come from someone not on the committee?
That doesn't really matter.
Then I'll make a motion to approve the proposed rules
Pending the governor's office approval.
did to move forward.
One more caveat that I left off. In your rules package, you'll also notice that I amended. I will show you where I
The fees.
The fee, so R423-205, and this is based on prior discussions about charging inspection fees. So the calculation is now built into that section just to codify it. But we did talk about it at the last meeting and felt that it was necessary to put it in rule. So it's not a surprise to anybody. It's already been discussed.
So I have a motion to approve the rules as proposed pending the governor's office approval. Do I have a second? A motion, a second, any discussion? All those in favor? Aye. Any opposed? Hearing none, motion carries. Thank you, Dr. Gandhi. I think we probably have time for Ms. Kianavong's report to do that quickly and then call to the public before we get to 4:30. So Jen, take it away.
Good afternoon, board members. Jennifer Geldevong, Deputy Director. Just a few things in my report. The first is that I wanted to, with our team, welcome 3 new staff members. Hannah Boltz, our licensing division manager, has rounded out her team with 3 new licensing administrators. Allison Akanoski, Erica De Leon, and Bridget Perez. We have Erica and Bridget with us, so ladies, we're happy you're here. Thank you. Okay, and then the last thing that I have has to do with the APHA Substance Use Institute, the APHA Institute on Substance Use Disorders, rather. So in late May, Jenica and myself had the opportunity to attend the Institute in Salt Lake City, Utah. The University of Utah School on Alcoholism and Other Drug Dependencies, which is now known as the APHA Institute on Substance Use Disorders, was actually established all the way back in 1951. And throughout the years, it has expanded its scope to keep pace with the increased awareness of the health and social problems of alcoholism and other drug dependencies. In 1983, a pharmacy section was formed and has continued on an annual basis in different forms and under different names since this time, with the exception of 1 year in 2014. So this has been going on a really long time. The APHA Institute provides attendees with information and guidance regarding addiction education, as well as increasing the awareness of health and social problems related to alcoholism and other drug dependencies. Throughout a variety of unique and interactive sessions over the course of 4 days, attendees not only learn about pharmacology, but discover the personal and emotional effects around alcohol and substance use disorders. So this was my 2nd year attending the Institute, actually attended with board member Snare last year. And it was just as impactful to me this year as it was last year. And last year I did share my experience with the board, but because this was Jenica's first time attending the Institute, she's prepared a statement that she would like to share with you.
Thank you, Dr. Kiana Vong. I'll keep this quick, board members. I'd like to thank NABP for awarding me a grant to attend the Institute. I arrived at Salt Lake City with an open mind and a goal to take away some additional perspective that I could apply to my work here with the board. I can confidently say that I came home with what I had hoped to gain. We heard from a pretty wide range of speakers, from those working in the field and discussing topics such as pharmacotherapy to first-hand stories of individuals who struggled with substance use disorders themselves. We also had the opportunity to end each day with attendance in a 12-step meeting. It was definitely an impactful experience, and I'm grateful to have had the opportunity to attend. If anybody has any questions about it, please feel free to reach out to me. I'd be happy to share my experience with the Institute with anybody who's interested.
Thank you both. Appreciate it.
Thank you.
All right. Let's do call to the public.
Roger Morris, while you're getting your numbers up there, had 3 things. Real quickly, thank you for the folks who attended at the Midwestern class that Dr. Gandhi talked about. It was great and really appreciated. The second, some of you may know this, but I'm not sure all of you do. The state of Arkansas passed a law about a month ago that prohibits the common ownership between PBMs and pharmacies, either directly or indirectly. That will take effect on January 1st, 2026 at the moment. There are a whole bunch of lawsuits filed against the state of Arkansas as to whether that law will go into effect or not. We'll see how that plays out. But if it takes effect, there will be numerous pharmacies that will need to shed pharmacies in Arkansas, which is the obvious one. But then there may be a number of pharmacies, including pharmacies here in Arizona, that ship drugs into Arkansas. That will need to give up that Arkansas license. The reason I raise this is Arkansas will be notifying any pharmacy whose license they intend to not renew as of January 1 on October 1st, that they will do that. That means between October 1st and December 31st, there will likely be a bunch of changes of ownership, sales of pharmacies, activities that will affect this board and some of its licensing, which is always messy at the end of the year. The other piece that you need to know is there are 10 states right now that either have introduced similar legislation or have announced that they will as of January 1. So you're going to see a whole bunch of activity with changes of ownership, pharmacy issues or like, assuming the courts don't stop this. So I simply just wanted to alert you that there's going to be some sea change as to what's going on. And it may affect staffing and issues, particularly at the end of this year. So we'll see what happens with it. The other one I wanted to do, Saturday, I had the opportunity to present with several of my colleagues at the Arizona Pharmacy Association's annual conference down in Tucson, and I did a pharmacy law update. During it, we talked about the rulemaking process, some of the rule issues. And Dr. Gandhi, I had several people who asked how they could get their thoughts on certain rules in, and I suggested they all reach out to you and your staff to send their suggestions, although I did say they could CC me as well. So you may be getting a number of suggestions.
Thank you, Roger. Do we have anybody on the line? All right, hearing none, we will recess for the day. Thanks, guys, for a productive meeting. And thank you, Ms. Davis, for pinch hitting this morning. I really appreciate it. I knew you would do a great job, but I appreciate you standing in this morning for me. See you all tomorrow at 8:30.